ಗುರುವಾರ ಶುಕ್ರವಾರ
ಯಾವ ಡೇಟ್ ಬೇಕಾ ಡೇಟ್ ಕೊಡಿ.
ನಾಳೆ ನಾಡದ್ ಬೇಡ ಸರ್, ಹೊರಗಡೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು, ಶುಕ್ರವಾರ ಕೊಡಿ ಅವ್ರು.
ಫ್ರೈಡೆ.
Well, that's one matter, my lord. Acquisition process is already taken place.
ಯಾವಾಗ ಬೇಕಿರಿ?
ನಾಳೆ.
ಕೊಡಿ.
Really did.
ಮೆಮೊಗಳೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಬಟ್ ನೀವು ಯಾವ ಡೇಟ್ ಮೆನ್ಷನ್ ಮಾಡ್ತೀರೋ ಆ ಡೇಟ್ ಬರುತ್ತೆ ಸರ್.
Yes, ಕೊಟ್ಟು.
That is the standing instructions given.
Adjournments, B group matters, serial number 29, 30.
That 29, I'm not well, my lord. I'm under medication, 2 weeks time.
Sir, it's a 2013 matter.
I'm sorry, my lord. I'm sorry because of my personal, I'm not,
Take a date of your choice, but no further adjournments. No
Because-
2 weeks and all in this matter.
because
It's a
I'm,
2013 matter.
I'm under medication, therefore I'm requesting.
Sir, do you mean to say for 2 weeks you will be indisposed, unable to come and argue the matter?
Today I've got an appointment with the doctor.
Today I don't mind granting adjournment, but it will not be adjourned by 2 weeks. You take it on Thursday or Friday.
Yes.
Yes.
19th, 19th,
12th.
19th, my lord.
19 ತುಂಬಾ ದೂರ ಆಯ್ತು sir. We'll have it on ಆಯ್ತು ಕೊಡಿ. 13th, is it okay with you?
13th.
Yes, 13th.
13th.
32 man. 32.
Sir, please mention it when it is called, sir.
31 to 35.
We'll call it page wise.
32 man. 32. Serial number 32.
32, sir.
Next week wait.
Date ಕೊಡಿ. 32.
18.
ಮತ್ತೆ 2016.
Serial number 34, my lord.
Ah.
I pray for 1 week time, my lord. An order has been passed by the DC in my favor, my lord. I produce the order copy, my lord. I pray for 1 week time.
Yeah, for whom?
I am for petitioner.
Date ಕೊಡಿ.
19.
Please, my lord.
36 to 40. 41 to 45.
Serial number 44, my lords. Short accommodation.
44, I am for the petitioner. Next week, any date.
ಆಯ್ತು, ಡೇಟ್ ಕೊಡಿ. ಅಥವಾ 44 ಸುಮ್ಮನೆ 1 week ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, date fix, date fix.
ಆಯ್ತು, ಡೇಟ್ ಕೊಡಿ.
20th. 20.
Great.
46 to 49. 50.
Yes, correct.
Serial number 1, list 1. Sri Hari AV.
Mission format.
Good.
Lordship 29 to consent award.
It is followed up, my lord. It's settled between the parties and before the OS local. It can.
Yes. General award, consent award.
Rajkumar. Government.
AGA for R1, R2 and R3 P. Chandrasekhar. Disposed of.
Next year is your lordship's order, they have been closed. Order ಹಾಕಿದ್ದಾರೆ, ತಮ್ಮದೇ order ಹಾಕಿದ್ದಾರೆ.
I disposed of ಮಾಮೂಲ್ ಮಾಡ್ತೀವಲ್ಲ ಹಾಗಾದ್ರೆ. If anybody has got any
No.
ಅಲ್ಲ rival claim.
ಇಲ್ಲ, settle out, suit tax ಮಾಡ್ಕೊ.
To Rakshita JD. Kashinath JD.
I'm up here for the petitioner, my lords. I have received the compensation in respect of 30 guntas for the acquisition, my lords. But in respect of mango trees, mulki crops.
Hearing for the
banana
respondents
trees,
in this case, my lord. Copy of the notice has been served to us.
Endorsement has issued by rejecting my representation, my lords. 80 in page number 23, my
For
lord.
this, should you not go to the civil court?
Sorry, my lords.
Civil court, you should go to the civil court, no madam. Anyway, AGA for R1
Yeah.
and 4, R1 and 4.
Vignesh. This is Pradeep Kumar, HL Pradeep.
HL Pradeep Kumar.
2-3 HL Pradeep Kumar. Call next week, objections if any by them.
Please.
3 Prasann Kumar. RS.
Petitioner in this matter. Petitioners are before your lordship challenging the acquisition notification issued by the PWD department in respect of the land measuring 1 acre 30 guntas for purposes of construction of the STP, my lord. The notification at page number 22, my lord. May kindly be seen. Page number 27, the notification is starts from 22, the relevant page at page 27, my lord.
What is this here? Put a newspaper publication over here.
acquisition notification, my lord. Acquisition notification.
Do
it has been
not
published.
produce a certified copy of the acquisition notification. Should you not
No, no,
produce?
paper I have produced, my lord. The newspaper cutting I have produced.
This will not do,
I'll-
sir. You'll have to produce.
I'll procure it and produce it, my lord. In the meantime, lord, they're conducting the survey proceedings and all pursuant to
Then
this
what's wrong
notification.
with that? What's wrong with that? Tell me.
Lord, the alternative land is available for farming of the
But you
STP.
file objections. They will issue preliminary notifications. They will call for objections. You file.
Lord, we have filed objections and see the deputy commissioner has not complied the mandate under section 15(2) of the Fair Compensation Act.
Final notification or
The
preliminary
preliminary
notification?
notification, Lord.
Where is the question of challenging the preliminary notification, council?
Lord, consequent to this notification, Lord, the survey proceedings, etc., consequently one and on, it happens and final notification will inevitably, it will come.
You
Lord,
can't presume that way. It could. Fair compensation.
Even the deputy commissioner has not given a hearing for the land losers, Lord. The collector shall give the objector an opportunity of being heard in person or by any person authorized by him in this behalf or by an advocate and shall, after hearing all such objections and after making such further inquiry, Lord, if any, as it thinks necessary, either make a report in respect of the land which has been notified under subsection 1 of section 11 or make different reports in respect of different parcels of the such land to the appropriate government containing his recommendations on the objections together. Lord, on the basis of the objections issued by Lord, filed by the land losers, Lord, the land acquisition has written the objections of the land losers to the deputy commissioner, Lord, may kindly find at page number 78. Page number 78, my lord, the second paragraph, idurante it starts from, and after 4-5 lines, my lord, ulidante, underlined portion, my lord, ulidante, Kamasandra survey number 39/1 ಜಮೀನಿನ ಭೂಮಾಲೀಕರಾದ ಶ್ರೀ ಈಶ್ವರಪ್ಪ ದಿ petitioner, my lord, ಗುರುಸ್ವಾಮಿರವರು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿದ್ದು ವಿಚಾರಣೆ ಸಭೆಯಲ್ಲಿ ಹಾಜರಾಗಿ ಸದರಿ ಯೋಜನೆಗೆ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲು ಪ್ರಸ್ತಾಪಿಸಿರುವ ಜಾಗದಲ್ಲಿ ತಮ್ಮ ಪೂರ್ವಜರ ಸಮಾಧಿಗಳು ಇದ್ದು ಭೂ ಸ್ವಾಧೀನಗೊಳಿಸಿಕೊಳ್ಳುವುದು ಸೂಕ್ತವಲ್ಲ ಹಾಗೂ ಉಳಿಕೆ ಜಮೀನಿನಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿದ್ದು ತಮ್ಮ ಜೀವನೋಪಾಯಕ್ಕೆ ಸದರಿ ಜಮೀನು ಒಂದೇ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ತಮ್ಮ ಹಕ್ಕಿನ ಜಮೀನನ್ನು ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗೆ ನೀಡಲು ನಮಗೆ ಒಪ್ಪಿಗೆ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಮುಂದುವರಿಸಿದ್ದಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿಸುವುದು ಎಂದು ಇಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ರಿಪೋರ್ಟೆಡ್ ಟು ದಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್. Even after this thing, Lord, the deputy commissioner has not given a hearing.
The deputy commissioner need not give you a hearing, sir. Where is it contemplated? Deputy commissioner should hear you. Show me. Show me in law. He has to act on this and take a decision whether final notification has to be issued or not.
Please, it has to be reported to the government. That has not been done.
It will be done.
Please.
Work on it.
It's internal communication.
And my lord, alternatively, the land, see, government land is available just next to the land
Okay.
of the land.
AGI accepts notice for respondents. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಪಟಿಷನರ್ ಅಲ್ಲ. The respondents have initiated acquisition proceedings in respect of certain lands in Kamasandra village. And it is submitted that it includes the lands of the petitioners concerned. Full stop. In this regard, A preliminary notification has been issued as contemplated under the provisions of the Right to Fair Compensation so and so Act. Full stop. Subsequent to issuance of the preliminary notification, the petitioners have submitted their objections. Which is pending consideration before the authorities concerned. Full stop. The state is yet to take a decision whether to acquire the land of the petitioner or not. Petitioners or not. Petitioners or not. Full stop. The final notification has not yet been issued. Full stop. Next para. Under the said circumstances, the writ petition has to be considered premature. Premature. Full stop. The court cannot presume that the case of the petitioner will not be considered by the respondents in accordance with law and issue orders. Full stop. If the respondent authorities decides to acquire the land of the property and land of the petitioner's consent, well, petitioners, then in that event, the petitioners will have a right to challenge the same in the manner known to law. Full stop. Next para. As the writ petition is premature, the same is hereby dismissed. Yes.
4, Narsimraju. Serial number 4, Narsimraju.
Serial number 4 and 20.
I have filed Wakalat. Next one, date on, 18 date, I will verify and make submission.
4 and 28, both are.
4 and 28.
On a Monday, last week in the only to
Notice
consider
ಆಗಿದೆಯಾ?
representation.
Easy R1 and 3.
I filed Wakalat.
Here PV Chandrasekhar. ಯಾವಾಗ ಬೇಕು?
18th or 19th.
18th.
28 also same.
28 also.
28 28 ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯೋ ಇಲ್ವೋ?
Notice
ನಾನು ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ.
ನೀವು ವಕಾಲತ್
ಹಾಕಿದ್ದೀನಿ. ಲೆಸನ್
20 ನಲ್ಲಿ 28 ಅಲ್ಲಿ ರಾಮಕೃಷ್ಣ ನಿಮ್ದಿಲ್ಲ ಇದ್ರಲ್ಲೇ. ಆಯ್ತು, ಇರ್ಲಿ ಬಿಡಿ. Registry is directed to delete the name of Sri C. Ramakrishna and show the name of Sri PV Chandrasekhar as the advocate appearing for respondent number 2. Call on. Add it.
89.
89. ಇದು ಅಷ್ಟೇ ಅದು ಅಷ್ಟೇ.
5.
ಇಲ್ಲ, ಇದು ನೋಟಿಸ್ ಆಗಿದೆ 28ಗೆ. ಅಷ್ಟು ಮಾತ್ರ ಮಾಡಿ.
Petitioner.
ಇದು ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು. ಕಾಲ್ ಆನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಫ್ ಎನಿ ಬೈ ದೆನ್.
Kindly pass over, my lord. Affidavits file my petition.
Pass over. 5 is passed over.
6.
The petitioner in this matter, Lordship.
Respond number 2, your lordship.
So, ಇದರಲ್ಲಿ ನಾನು additional documents ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. So objections ಇದೆ. Kindly have it on 19th, Your Honor.
The request of petitioner, call on 19th.
Your lordship, a small submission. In the cause, this my senior TS Amar Kumar name is shown. In fact, is no more. And in the place of that, KR Krishnamurthy name may be shown.
Whose name?
KR Krishnamurthy.
ಬರ್ಕೊಡಿ. ಚೀಟಿಲ್ ಬರ್ಕೊಡಿ.
Yes.
ಸರಿಯಾದ spelling ಅಲ್ಲ. Registry is directed to delete the name of Sri T.S. Amar Kumar, the name of Sri so and so as the advocate appearing for respondent number 2. Call on. Date
7.
ಅಲ್ಲ, 19th ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ರಿ?
19th.
19th.
19th. Serial number 8. 7. Rajeshwar.
My lords, kindly press time in this matter.
Pass over. Next.
ಅವ್ರೇನೋ ಟೈಮ್ ಕೇಳ್ತೀರಲ್ಲ ಸರ್.
Senior is not available, my lords.
Total 2 ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಬರ್ತೀನಿ ಅಂದ್ರು. ರಾಜೇಶ್
ಅಲ್ಲ, ಇವರೇನೋ ಟೈಮ್ ಕೇಳ್ತೀರಲ್ಲ.
Senior's grandfather is
ಆಯ್ತು, ಯಾವ್ದು ಬೇಕು ಹೇಳಿ.
any day. Next week.
ಅಲ್ಲ 2-3 days ಬಿಟ್ಟು ತಗೊಳ್ಳೋಣ, ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೇನೋ ಅರ್ಜೆನ್ಸಿ ಅಂತ 2014 ಮ್ಯಾಟರ್. 3 days ಗೆಲ್ಲ ಮುಗಿಯುತ್ತಲ್ಲ, ಕಾರ್ಯ ಎಲ್ಲ ಮುಗಿಯುತ್ತೆ.
13th. 12.
12-13, whenever you want, when you want.
12.
12, at the request of respond number 2 and 3, call on 12.
8, Ganapati Bhatt.
IA for amendment of petition, my lord.
Hmm.
As I have sought, my lord, certain that facts was not narrated, endlessly break. Therefore, my lord, all facts that I have, my lord, sought amendment.
Yes, we'll allow it.
With
All right.
liberty to file additional objection, man.
Goes without say.
Please.
Yes. Orders on IA 102/2023. The aforementioned IA is filed to amend the writ petition. Full stop, accept in the caution. The same is allowed. Petitioner is permitted to amend the writ petition and file amended writ petition within a period of 2 weeks from today. Full stop. Respondents are granted ಎಷ್ಟು time ಬೇಕು?
In 2 weeks, we'll file.
An additional 2 weeks to file objections to the amended writ petition, if any. Amended writ petition ಅಷ್ಟೇ, if any. Yes.
Please,
So the
watch out.
9, Maya Ola. Sachin, BS.
Yes, the writ petition is of the year 2017. The advocate for the petitioner submits that there are no instructions to go on with the matter. And they intend to file a memo of retirement. And they intend to retire. And they intend to retire from the case. It appears the petitioner is not interested in prosecuting the writ petition. The writ petition dismissed for non-prosecution. Yes.
10, Sridhar G.
10 by lords,
Where
they
had to
are
file a
requested
report.
for 1 week time to submit some documents to before survey.
The court, my lord, this court is directed, my lord, the government to file a affidavit of
It is the
concerned
data-
officer. Why the RTCs, my lord, after it is transferred to BBMP, my lord, is not.
Yes, when will you do it? It's a simple thing.
13th date is fixed.
For what?
Petitioner themselves, my lords, it's that time to, for 1 week time for filing. So
For what? You are required to.
Surveyor fixed the date for.
What has happened, my lord,
Survey.
in the December, the honorable court passed an order for survey.
What do you people want? You want adjournment?
Yes, my lord, it may be taken in the next week. my lords.
Right, call on 18th ಬೇಡ 19th.
19th,
Much of.
19th,
ಆಗತ್ತೇನ್ರಿ ಕೇಳಿ ಆಮೇಲೆ ಸುಮ್ನೆ ಮತ್ತೆ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೋಬೇಡಿ.
19.
ಮಾಡ್ಬೇಕಪ್ಪ 19 The request of learned GA, call on 19th.
11, SB Mukkanappa. Sheet number 11, SB Mukkanappa.
ನೋಡಿ ಅವ್ರೇನ ಮುಕ್ಕಣ್ಣಪ್ಪನ ಇಲ್ಲ ಅಲ್ಲ
ಇಲ್ಲ
ನನ್ನ ಪಾಸ್ವರ್ಡ್ ಮಾಡೋಣ. ಪಾಸ್ವರ್ಡ್
12, Prince Isaac. Sheet number 12,
Respondents. State government has to file an affidavit after direction of some.
Yogesh Naik is got instruction.
ಏನ್ ರಾಜ್ಕುಮಾರ್ ನೀವು ಎಲ್ಲದರಲ್ಲೂ ಬರೀ
ಅವ್ರ ಹತ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡಿದಾರಂತೆ. Is got instruction. Kindly have date of tomorrow. Today is not the
The request of AJ, call on date ಕೊಡ್ರಿ 13.
11, ಯಾವ್ದು ಬೇಕು ಸರ್? 12th, 11,
ಆಗುತ್ತಾ ಗ್ಯಾರಂಟಿ?
Yes.
ಆಯ್ತು
12th,
ಆಯ್ತು 12th.
13, Vasant Kumar HT.
For the respondent, BBMP. They may be permitted. In our records, we have not handed over the site to the slumlord merchants. It is still vacant. In our records.
In the identical cases, this Proceedings bench has ordered directing the BDA to provide the site and further directed the slum board to pay the sum of rupees 7,50,000 to all the petitioners.
When site is vacant and not handed over to slum board, where is the question of slum board granting any damages to you?
No, Lord, because already they have constructed.
What is annexure K and J?
ನೋಟಿಸ್ ಮುಂದುವರೆದ ನಿಯಮ 11 ರೀತಿಯ ಪ್ರಾಧಿಕಾರ ಹಂಚಿಕೆದ ನಿವೇಶನ ಭೌತಿಕ ಸ್ವಾಧೀನ ನೀಡಿರುವುದರಿಂದ ಸದರಿ ನಿವೇಶನ ಕೊಳಚೆ ನಿರ್ಮೂಲನಾ ಮಂಡಳಿಯವರು ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವುದರಿಂದ ದಿನಾಂಕ 20/9/2018 ಬದಲಿ ನಿವೇಶನ ಸಮಿತಿ ತೀರ್ಮಾನದಂತೆ ಪ್ರಾಧಿಕಾರ ತಮಗೆ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ಅವಕಾಶ ಇರುವುದರಿಂದ ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
Ibro objection
ಹಾಕಿದ್ದಾರೆ.
Plumboard and BDA.
BDA, I have filed the objection.
Both have filed objections.
What have you stated in?
My lord, in my BDA is concerned, my lord, we have issued the sale deed in the year 2007.
No.
Now in the, after 8 years, my lord, 2015, he comes and my, in the.
Okay, what is the sum board saying?
My lord, I have filed my statement, additional statement of objection. In that I have produced R4. It is the memorandum of understanding between the BBMP and the slum board, where the BBMP has given us the land to only to develop and handed over it back. I have produced all the documents and I have produced the beneficiary list, everything. It is handed over back to BBMP. Now it is in the custody of BBMP.
I'll take
My lord,
this
your
document.
lordship may have it page number 6 of.
Then we'll
The
impose
document
cost.
found over here, I'll take the
No, we'll impose cost. How can you make a contradictory
Lord.
submission?
As on today, it is still
You file an
vacant.
affidavit. You
I'll-
file an affidavit of a responsible officer.
Yes.
Yes, but
I'll take
the
these records.
advocate for you're for BBMP, na?
BBMP.
Advocate for BBMP submits that there is no slum existing on the property concerned. Whereas, whereas the advocate for slum board submits that they have filed their objections and
Even affidavit also we have filed.
they have stated that BBMP had handed over the property to the slum board
board.
and slum board has in turn developed the same and has handed over back to the BBMP. Full stop. Net result, the petitioner is left without his property. For which either of the respondents have to compensate. Either of the respondents have to compensate. Full stop. BBMP is directed to file an affidavit of a responsible officer as to how they took custody of the property. But the same was allotted to the petitioner by the BDA. And the procedure adopted to hand over the property to the slum board. And what is the nature of the property as on today? Tola. Date today.
2 weeks.
Date 2 weeks with date today.
23, 23.
Okay, one of you will be in serious trouble.
Also.
If
Because
it is
some
not
records we know
amicably
Kalidas.
resolved, one of you are going to be in serious trouble. Yes,
Serial number 14, Sri Harsha.
Lords, for the petitioner, my lords. Lords, I'm seeking for the quash of award notice, my lords, it has been issued by the respondent 2 and 3, my lords. My lords, my condition is that, my lords, as per section 26, the award notice has not been
an observation. Comply with observations.
please, my lords.
1 week time is granted to the need.
May filed Wakat, objections also filed.
Let them comply with observation.
Alternative remedy ಇದಾವೆ ಸೊ ಮೇಲ್ಟವಿಟಿ ಬರಲ್ಲ ಮೇಲ್ಟವಿಟಿ ಬರಲ್ಲ
The representation has already been given.
ಅಲ್ಲ ಇವ ಲಾಸ್ಟ್ ಹೇಳಿಸಿದೆ seeking to pass the award is passed under the new land action act only. They say it is lesser compensation, you pay the recent compensation. I have filed an objection containing that if you dissatisfied the quantum of the market value, your remedy is to seek for reference before the competent authority. 64 ಕೆಳಗಡೆ. This court under writ jurisdiction cannot consider that this is the particular market value, true and correct market value. 64 ka alternative remedy ಇದೆ. That is my objection, mentality ಮೇಲೆ. If you are dissatisfied with the market value, yes, you seek reference. New Act 64, Old Act 18.
Yes, Bane.
I have filed ವಕಾಲತ್ and objections
Okay.
also.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ರೆ objections ಆಗ್ಬಿಟ್ಟಿದ್ದೀನಿ. 19/24 ಹಾಕಿದ್ದೀನಿ.
Yes, AGA accepts notice for notice ಆಗಿಲ್ಲ ಅಲ್ಲ?
Yes.
AGA accepts notice for respondent number 1. P. Chandrasekhar accepts notice for respondent number 2 and 3. Full stop. Respondent number, notice to respondent number 4 is dispensed as the, as not necessary, as the writ petition is dismissed. Huh? Full stop. Next. The petitioner, on the comma, the petitioners on the matter. The petitioners on the ground that their land has been acquired for the purposes of KADB and adequate compensation has not been paid to them, have filed the presented petition with the prayer to set aside the
The award dated 18/12/23, my
the
lord.
award passed by the special land acquisition officer and for issuance of a writ of mandamus to direct them to pass a fresh award taking into consideration the recent market value of the land. Full stop. If next para, if the petitioner is aggrieved by the award passed by the special land acquisition officer, comma, he has an alternative efficacious remedy as per section 64 of the Right to Fair Compensation Act. Full stop. Next para, as the petitioner is having an alternative efficacious remedy, comma, reserving the said liberty to the petitioner, comma, the writ petition is hereby dismissed.
It's 3 months time may be.
No time, sir. Yes.
15, Nagaraju.
For petitioner, my lord, last date, status quo was not extended. Status quo. Status quo order was granted, my lords, last date lagila 22/8 and ಅದಕ್ಕೆ that application is there. ಇದ್ರಲ್ಲಿ respond numbers 8 objections ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. Service of notice.
Status quo ಕೊಟ್ಟಿದ್ವಾ? Non-compliance of observation ಯಾವ್ದಿದೆ?
ಇಲ್ಲ ಅದೆಲ್ಲ ಇದೆ. Matter was heard and the notice was issued ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅಂತ emergent notice ಕೂಡ ಆಗಿತ್ತು. But by oversight, my lords, the status quo order was not extended.
Yes, at the request of the petitioner, 1 week time is granted to comply with office objections. The order of status quo granted earlier is extended till next date of hearing. See, this is the problem. If we, once we grant an interim order, you won't comply with office objections.
Yeah, my lords.
If office objections are not complied with by next date of hearing, then bada bada, it's all right. See, this is the problem.
Sorry, my lords, apologies.
Call on vara bit date good.
Notice ಆಗ್ಬೇಕು, notice ಹೋಗಿದೆ.
Notice serve ಆಗ್ಬೇಕು.
Await ಇದೆ.
ಯಾರಿಗೆ?
To respondent number 7.
ಆಯ್ತು, whether if they don't comply with office objection, I am vacating the interim order.
17. Serial number 16, Shruti C. Jaganti.
I have taken steps, mister. I have taken steps to serve the other council. Then why should I extend the interim order, I say? No, I am not extending the interim order. Bani.
Is appearing.
ಕೊಡಿ writ petition. Interim order ಇಲ್ಲ, ಎಂತದು ಇಲ್ಲ.
My lord.
ಕೊಡಿ steps ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ ಇವರು?
ತಗೊಂಡಿರ್ಬೇಕು, my lord. ಅದಕ್ಕೆ just cross check. Give me 5 minutes to know.
Pass over. Interim order ಇಲ್ಲ. Pass over.
Pass over.
ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ? ತಗೊಂಡಿಲ್ಲ, ಇಲ್ಲೇ ವೆರಿಫೈ ಮಾಡಿದ್ದೀವಿ.
My lord, ಈಗಲೇ ತಗೊಳ್ತೀನಿ ನಾನು.
ತಗೊಳ್ಳಿ, ಅದಕ್ಕೆ ನಾನು ತಗೊಂಡ್ಬಿಟ್ಟು ಎಲ್ಲ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ.
ಈಗಲೇ my lord, pass over
Yes, at
ಮಾಡಿ.
the request of the petitioner, call next week. 1 week time is granted to comply with, ಈ ರೀತಿ ಮಾಡಿ, at the request of petitioner, 1 week time is granted to comply with office objections and take steps to answered respondent. In the light of petitioner, ಅದೇನಿಲ್ಲ, pose the matter for consideration of interim prayers next week only if the petitioner complies with the office objection and take necessary steps to have the answered
A
respondent
threat
served.
of alienation ಇದೆ ಈಗಲೇ ತಗೊಳ್ತೀನಿ.
You do what.
23 ಐಟಮ್ ತಗೊಂಡಿದೆ ಮೇಡಮ್.
Mister, this is the problem. You people come and beg the court. You sit on our head. First of all, you don't file the writ petition properly.
Apologies, my lord.
No, listen, this is the attitude. And people like me, we become bad with the bar for this idea, asking you to be a bit disciplined. What do? You don't file the writ petition properly.
My lord,
Then you sit on our head. Then we grant some interim orders. Then office objections are not complied, even steps are not taken.
Lord, sir.
When trial court grants an interim order, ex parte interim order, within 24 hours, you are supposed to comply with it.
My lord, my only submission.
No, I'm not granting a
Kindly pass it over, my lord. I'll just-
Mister, listen,
One minute.
you comply with the office objections,
My lord. Yes, my lord.
you take steps, move the court, we'll take it up.
Yes.
One week. Date ಇಲ್ಲ next week, ಬೇಕಾದ್ರೆ move ಮಾಡ್ಕೊಂಡು ಬರ್ಲಿ. No interim orders, okay? ಹಾ.
Chaganti.
Appear for the petitioner National Highways Authority, my lord.
Hmm.
In this court, office objection number 1 has been already complied with.
Hmm.
2, 3 and 4, my lord.
You comply with office objection, ma'am.
No, my lord, I'm pressing for an interim order. 3 and 4 need to be overruled, my lord, because annexure U, what has happened is that the writ petition number is stated in the order, but the date of the order is 12/2/2024, which I've correctly stated. The office has mistaken the writ petition number to be the number of the order. So 3 and 4 have to be overruled, my lord. I mean, if my lord would consider
No,
overruling.
I'll
these
pass it
objections.
over, just have a look at it.
No, 3 and 4, only 2, my lord, I can comply.
There are
with
no
saying-
3 and 4, madam. There are only 3 office objections over here. Just have a look at it. Torsi ಅವ್ರಿಗೆ.
My lord.
No, I will pass it over. I'll take it up later. Pass over.
17, Saran and Majge.
Petitioner, matter pertains to general award, my lord.
ಮಾಡ್ಬೋದಾ? Yes, AGA Arvan Pradeep Kumar, 2-3. General award consent.
One
award is
submission, my lord. Prayer ಅಲ್ಲಿ 56/4/4 ಅಂತ ಆಗಿದೆ. ಬರೀ 4 ಮಾತ್ರ, 56/4 only. Typographical error one.
ಪ್ರಾಪರ್ಟಿ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಪ್ಪ? ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ. There are observations, comply with it. I will take it up in the afternoon. ಪಾಸ್ ಓವರ್ ಕೊಡಿ ಅವ್ರಿಗೆ, ಕಂಪ್ಲೈ ಮಾಡಲಿ. ಸೊ ಯು ಮೇಕ್ ನೆಸರಿ ಕರೆಕ್ಷನ್.
18, Vasant Kumar. AM.
Senior representative.
18.
My lord, I appear for petitioner's counsel. My lord, originally, my lord, I am SP Kulkarni, my wakalat was there, my lord. Then I was, my lord, I was given the, my lord, seniorship, my lord, and automatically, my lord, wakalat of Nemachandra was the junior. He became a civil judge, my lord. Ultimately, therefore, my present colleague, my lord, Vasant Kumar has filed. There is no question of obtaining
She
NOC.
is directed to delete the name of Sri Nemachandra as the advocate for the petitioner.
Vasant Kumar has now filed the wakalat for colleague.
ಏನ್ recalling sir ಇದು?
It recalling, my lord, it was dismissed for that reason only. Communication gap was there, my lord, it got dismissed.
For non-prosecution. It was.
There is some delay, my lord, in
Listed in name of Nemachandra, my lord. It was there.
and my lord, nobody could know, my lord, that his name is flowed and
It's a 2014 matter, sir.
14
I'll
matter,
take the
my lord.
order, But
Oh,
please
yes.
go on with the
Oh,
matter.
very, very well. Next week, any day, my lord,
Go
convenient,
next
my lord,
week,
I will-
sir. Please go on with the matter now itself.
Today, my lord, I am handicapped because of 2 video conference matters. I am extremely sorry, my lord. One pattern matter was there. I was held up somehow. I got it, my lord. and
Sir,
I'm
it's a
coming.
2014 matter,
Yes,
sir.
yes. Even tomorrow, my lord, tomorrow I will be able to come. Tomorrow itself, my lord.
One.
Sorry, sir. I am sorry. Sir.
ಇದು 18 ಅಲ್ಲಿ 1 and 2.
My lords,
18.1 ಅಲ್ಲಿ
Alluru 1 and
4, 5,
LR application is.
LR applications, my lord, because he was not, they were not aware and the petitioners died and.
4, 5. ಆಯ್ತಾ ಫಸ್ಟ್ 18 ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಆನ್ IA 1 and 2 of 2024. 18.1 ಅಲ್ಲಿ 4 and 5 of 2024. The separate orders. The aforementioned IAs are filed. 18.2 nu ಇದೆಯಾ? 18.2 ನಲ್ಲಿ 1 and 2 of 2024. ಗೊತ್ತಾಯ್ತಲ್ಲ? The aforementioned IAs are filed to recall the order dated 16/1/2024 by condoning the delay in filing the said applications. Full stop. On 16/1/2024, the writ petitions were dismissed for non-prosecution. Full stop. Accepting the cause shown in the application affidavit. Affidavit accompanying.
Application.
Rate ಆಗೋದ್ರಿಂದ ಅಪ್ಲಿಕೇಶನ್ ಆಗುತ್ತೆ, ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ will be there.
Accepting the cause shown in the application. Affidavit alla, application.
Yes, yes.
The aforementioned IAs are allowed. The order dated 16/1/2024 dismissing the writ petitions for non-prosecution is hereby recalled and the writ petitions are restored to file.
My lords,
Next.
my lords, I appear for R2 and R3, my lords, in this serial number 18, my lords. My present shall be marked, my lords.
ತೋರಿಸ್ತಾರೆ ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲಿ ಬರೋದು, ಆರ್ಡರ್ ಅಲ್ಲಿ ಬರಲ್ಲ.
Yes.
In
18,
ಒಂದು ನಿಮಿಷ, ಆರ್ಡರ್ಸ್ ಆನ್ ಇದು 18.1 ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಆನ್ IA 1, 2 and 3 of 2024. 4 and 5 ಆಯ್ತು ಆಗ್ಲೇ, ಆಯ್ತಾ, ಅದು ರೀಕಾಲ್ ಆಯ್ತು. ಈಗ 1, 2 and 3 of 2024. The aforementioned IAs are filed to bring the legal representatives of deceased petitioner on record by setting aside the abatement and also by condoning the delay. Full stop. It is submitted that the petitioner died on
6/6/2016.
6/6/2016. Full stop. The aforementioned IAs are accepting the cause shown. The 2826 days ಯಾರಿಗಾದ್ರೂ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ?
My lord, they were not aware. See, Lordship knows, my lord. Long day, Supreme Court 85, my lord says, parties will not be knowing, though he knows that his father goes to
No,
court.
but I have to ask you, sir, I am asking.
Yes. I don't think so. There is anybody.
Some advocate wanted his presence to be shown,
Yes,
but he is
that has
nowhere
to
to be seen. He has no
Presence
patience
has
even till
Yes,
the
yes.
case is
Yes.
adjourned.
That has to mark.
I don't know whoever he is. You have no objection, no?
Yes.
ಏನ್ ಬಂತು?
This is we're already files are sent. You have to secure files back again because January ಆಗಿದೆ.
ಇದು ಮೇಲ್ಗಡೆ ಕಾಸ್ಟ್ ಒಂದ್ 5,000 ಹಾಕಿ. ಯಾವ್ದಕ್ಕೆ? ಇದು ರೀಕಾಲ್ ಆಯ್ತಲ್ಲ. Subject the cost of rupees 5,000.
I obey whatever Lordship orders. I obey, my lord. That's all.
Is imposed on the petitioners payable to the account of Registrar General High Court of Karnataka. ಆಮೇಲೆ ಇದು accepting the cause shown, the aforementioned IAs are allowed, the delay is condoned, abatement is set aside, and petitioner, the proposed legal representatives of deceased petitioner are permitted to come on record. Full stop. The advocate for the petitioner is directed to amend the cause title and file amended writ petition within a period of 1 week from today. Files ತರಿಸ್ಕೋಬೇಕಾ ನೀವು?
ಆಯ್ತು.
ಫೈಲ್ಸ್ ತರಿಸ್ಕೋಬೇಕಾ?
ಯಾಕಂದ್ರೆ ಕಳಿಸ್ಬಿಡ್ತಾರೆ.
ಆಯ್ತು, ಒಂದ್ ವಾರ ಸಾಕಲ್ವಾ?
ವಾರ 10 ದಿವಸ ಅವ್ರು ಮಾಡ್ಬೇಕು ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್.
ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ರೇಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದು
18ಕ್ಕೆ ಹಾಕೊಳ್ಳಿ, 17-18ಕ್ಕೆ.
ಆಯ್ತು, ಕಾಲನ್ 19th ಹಾಕ್ತೀನಿ ಸರ್.
18.
18 ಬೇಡ, ನೈಸ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
Any date convenient. I am grateful, very, very grateful.
Yes, 19th.
5,000 in each case.
Yes, each case. Yes. Each case, more cases separate order.
19. Case Nagaraj Rao.
Petitioner in this case, LRs have to be brought on record. I will have. The petitioner is no more. He died on 5/3/2023. Where application has been filed, IA 123.
19.1 alla, orders on IA 1/2023. It is submitted that the petitioner died on
5/3/2023.
5/3/2023. The aforementioned IA is filed to bring his legal representatives on record. Full stop, accepting the cause shown, the same is allowed. The proposed legal representatives are permitted to come on record.
Obliged, sir.
The advocate for the petitioner is directed to file amended petition by amending the cause title. Is permitted to amend the cause title and file amended petition within a period of 1 week from today. Yes, 19.1 ಅಲ್ಲಿ ಏನಾಗ್ಬೇಕು?
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಫೈಲ್ಡ್ ಐ ಥಿಂಕ್ ನಾಟ್ ಸರ್ವ್ಡ್ ವಿತ್ ಎನಿ ಕಾಪಿ ನನಗೆ ಕೊಡ್ತಾ ಇದಾರೆ ಎಂತದ್ದು ಗೊತ್ತಿಲ್ಲ
ಅಲೋ ಮಾಡ್ಬೋದಾ?
ಯಾರು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ಅದೇ ಪೆಟಿಷನರ್
ನೋಡಿ ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿ, ಈಗಲೇ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ಮಾಡೋಣ, ಇಲ್ಲ ತಕರಾರು ಮಾಡೋದಾದ್ರೆ ಟೈಮ್ ಕೊಡ್ತೀವಿ.
ಪ್ಲೀಸ್
ಅಲೋ ಮಾಡ್ಬೋದಾ?
ಸೈಟ್ ಓನರ್ಸ್ ಅಂತೆ, ವಿ ಆರ್ ಆಲ್ಸೋ ಸೈಟ್ ಓನರ್ಸ್.
ಮಾಡ್ಬೋದಾ? ಮಾಡ್ಬೋದಲ್ವಾ? ಓಕೆ.
ಕಾಪಿ ಇಸ್ ನಾಟ್ ವಿತ್ ಅಸ್ ಬಟ್ ಎನಿವೇ ಮೈ ಲಾರ್ಡ್
ಅವ್ರಿಗೂ ಕೊಡ್ರಿ ಕಾಪಿ.
ಕಾಪಿನೇ ಕೊಡಲ್ಲ ಅವರು, ನನಗೂ ಈಗಲೇ ಕೊಟ್ಟಿದ್ದು, ನಾನು ವಿ ಆರ್
Yes, orders on IA 1 and 2 of 2023. The aforementioned IAs are filed to bring the proposed impleading applicants as petitioner number 28 and 29 on 29-20. ಏನ್ ಬಂತ ಹೇಳಿ?
ನೀವೇ
29
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಷ್ಟೇ.
ಏನ್ ಸರಿ ಬರ್ಲಿಲ್ಲ. ಮತ್ತೆ
ಬೇಕಾ ಬೇಡ ಅಂತ ಹೇಳ್ಬೇಕಷ್ಟೇ, ನಮ್ದೇ
ಫೈಲ್ ಟು ಇಂಪ್ಲೀಡ್ ಬ್ರಿಂಕ್ ಅಲ್ಲ. ಈಗ ಓದಿ. Full stop. None of the parties have any objections to allow the same. Full stop. Except in the cause shown, the aforementioned IAs are allowed. The proposed impleading applicants are permitted to come on record as petitioners 28 and 29. Come on record as petitioners 28 and 29. The advocate for the petitioner is directed to amend the cause title and file amended petition within a period of 1 week from today.
Obliged. Interim order has to be extended.
Interim order if any is extended till next date.
Obliged.
20. Sarath Kumar Shetty.
Yes, who has filed for vacating stay?
For the respondent.
If hearing the main matter itself, my lord.
Yeah. Sir, 2022 matter. Namdi 24 matter.
Short date may be given, my lord.
Why short dates?
Alla, our records produce ಮಾಡಬೇಕು government.
ಇದು
Directed to produce the records.
already I filed a memo for disposed of the earlier matter. ಹಾಕಿದ್ದೀನಿ.
ಅದು ನಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
Same stretch of the highway, national highway. Again, they have to file the same petitioners in this all cases.
The matters.
What happened? It's very difficult for.
Notice to me, my learned friend has visited the dispute site at.
Yes, also.
Along with the chief executive of the required mail or the land acquisition officer. And noted the disputed site mail which has been casualty, which has been done when learned friend himself suggested that we will sort it out the issue.
Yes.
He himself has suggested that we will sort it out the issue mail out of the settlement factor.
Sir, it's a highway matter.
Yes, my lord. Because
It is being acquired for wayside amenity or.
Casualty has been done, my lord.
ಅಲ್ಲ ಯಾವ್ದಕ್ಕೆ ರೋಡ್ ವೈಡ್ನಿಂಗ್ ಅಕ್ವೈರ್ ಮಾಡ್ತಿರೋ ವೇಸೈಡ್
Necessary.
ಅಕ್ವೈರ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲಿ ಏನಾಗಿ
ಸೆಕೆಂಡ್ ಟೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಅದು ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಇದು ನ್ಯಾಷನಲ್ ಹೈವೇ ಅಕ್ವೈರ್ ಮಾಡ್ತಾ ಇರೋದು ರೋಡ್ ವೈಡ್ನಿಂಗಿಗೋ
Road winding.
ಅಥವಾ ವೇಸೈಡ್ ಫೆಸಿಲಿಟಿಗೋ?
No, road winding.
Then where is the case for you? Why should we extend the?
Earlier court has also considered there is no merits of the case, we will dispose of.
Sir, go on with the matter, sir.
This stretch of not, my lord, violation act next week or week after.
No, sir, go on with the matter. See, it's a very wrong policy. According to me, it's a very, very wrong policy to grant stay against formation of a highway.
It's a Udupi, Your Honor. There's a lot of accident for this season. Very straight down places. So many accidents from the 5 years.
No,
Your
no
Honor.
further time is granted, sir. Please go. I'm vacating the interim order. That's all. You take how much over time you want.
I kindly appreciate this, my lord. After hearing the matter, my lord, there was a direction to produce the records. At least, my lord, he should show the courtesy of producing the records.
Your Honor,
before-
already
Kindly look at
producing,
the
already
previous
have
order.
seen the papers.
Kindly look at the
Every,
previous order. Why they are not producing the records, my lord, it is my learned to say.
already,
It was
there is
100
no
next
necessity to
time,
producing, Your Honor. Already is
he has to
completed.
directly
Only the
produce the
5
record.
is a only stretch of
Why he
100.
is not producing record,
Only
he is not
400
asking.
meters stretch of only national highway is disputed.
That irregularity will show, my lord. That is why
No, no.
after hearing.
Already is
But your
already.
photos give us Taurus Ray. Photos is the
Photos also is earlier repetition of filed, there is.
ಆ ರಿಪೋರ್ಟೇಷನ್ ಇದಕ್ಕೂ ಕನೆಕ್ಷನ್ ಇಲ್ಲ ಅದು ಅವ್ರನ್ನ ಬೇರೆ ಸ್ಟ್ರಕ್ಚರ್ ಇದು ನಮ್ದ್ರಲ್ಲಿ ಇಕ್ವಿಸಿಷನ್ ಅಲ್ಲಿ ಇದೆ ಲ್ಯಾಂಡ್ ಇನ್ಕ್ಲೂಡ್ ಆಗಿಲ್ಲ ದಟ್ಸ್ ವೈ ರೆಕಾರ್ಡ್ಸ್ ಹಸ್ ಬೀನ್ ಕಾಲ್ಡ್ ಫಾರ್ ನಾಟ್ ಅದರ್ವೈಸ್
One is, my lord, we have not been made parties to the proceeding.
Already
It is our
made,
property
already.
and it is acquired without making us party.
Show me on what ground can you object?
One is, my lord, not parties. Second is, my lord, 3C inquiry has not been held.
They have received, their objection also is received, they have filed, and then even though some of the landowners have received the compensation also. Only few people they have to drag on.
And,
Your Honor, what happened, there is no any documentary.
For
Some of the properties comes to government land. They are not
awarding the
producing the documents.
compensation, my lord.
Allah,
We have not
we
been
have
heard
gone
in
on
the matter,
merits.
we have not
There's
been
a lot
made
of
parties.
false suffice.
Some third party has been shown as the owner and the compensation is determined. That is the, our land is shown, our ownership is shown in the award. but
Okay,
we
ನೀವು
have-
ರೆಕಾರ್ಡ್ಸ್ ಯಾವಾಗ ತರ್ಸಕ್ಕಾಗತ್ತೆ ಹೇಳಿ
Okay, Your Honor, I'll,
ಯಾವಾಗ ಹೇಳಿ ನಾ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ ಅವತ್ತು ನೋ ಅಡ್ಜನ್ಮೆಂಟ್
only 10 days after 10 days.
ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಡೇಟ್
Right, and 27th, 26 or 27, this month.
ಅಷ್ಟು ಲೇಟ್
ಅಲ್ಲ, ನಾನು 20, ನಾನು ಇರಲ್ಲ, next week ನಾನು.
ಆಯ್ತು 26, 27 ಅವ್ರಿಗೂ ಬಹಳ ಖುಷಿ ಅದೇ ಬೇಕಾಗಿತ್ತು ವೈದ್ಯ ಹೇಳಿದ್ದು ಅಲ್ಲೋ ಅನ್ನ ರೋಗಿ
ಅಲ್ಲ, next week I'm not at station.
ಅದಕ್ಕೋಸ್ಕರ ತೋರ್ಸೋಣ
ಇಲ್ಲ, ಇಲ್ಲ. Your Honor,
Yes, sir, the request of
ಇವರಿಂದ
petitioners-
ಸ್ವಾಮಿ ಸುಮಾರು ಆಕ್ಸಿಡೆಂಟ್ ಆಗ್ತಾ ಇದೆ.
At the request
Only few peoples.
at the
I
request
show
of
the photographs.
Yes, at the request of petitioner, call on 26th.
Please.
No
Interim
further
order may,
attempt.
interim order may be extended.
Interim order if any is extended till next date of hearing. Finally call on ಅಂತ ಮಾಡಿ.
Please, finally.
21, ಅಭಿ ತೆಗಡೆ.
For respondent, press time. I have informed the other side counsel also.
The request for respondent call next week.
22, R. Srinivas Gowda.
Copy, my lord, served, my lord, just recently. I mean, a week ago, and we have sent it to client, my lord. We are yet to receive, my lord, instructions and details.
The request of respondent.
19
next week.
matters, copy served just.
Next week, Srinivas, please.
2 weeks, my lord.
Next week,
2 weeks, right, 2 weeks. fine.
2 weeks. 23, RP Shomsekhar.
My lord, in this case, my lord, they have filed application.
Number 3,
For vacating the interim order.
The last date of hearing,
ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿ.
the last date of hearing, my lordship had directed me to file the records. Just producing it, my lordship.
Yes, go on with the matter.
ಇಲ್ಲ ನನ್ಗೆ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡ್ತೀನಿ.
My lord, I will
ಸ್ವಾಮಿ,
look into it
ಇದ್ರಲ್ಲಿ-
and might make my submission. ಈಗ ಕೊಟ್ಟವ್ರೆ.
Sir, it's your case, go on with.
ಅಲ್ಲ ಯುವರ್ ಕೇಸ್ ಅಂತಲ್ಲ ಈಗ ಅವ್ರೇನೇನು ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟವ್ರೆ.
ಇಲ್ಲ, ಅದು ಏನಿಲ್ಲ ಸ್ವಾಮಿ, 3A notification, 3D notification.
ಪಾರ್ಟಿಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿ.
ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಷ್ಟೇ ಸ್ವಾಮಿ, because
ಏನ್ ಜಾಸ್ತಿ ಏನ್ ಬೇಡ, next week ಹಾಕಿ
interim
sir.
order, the developmental activities is not being taken well.
Next
And
week
there are
ಹಾಕಿ
been
sir. Take
series of
instructions.
revolt for payment of toll. ಇದು ಒಂದೇ ತಪ್ಪು ನಮ್ ಕಡೆಯಿಂದ ಆಗಿರೋದು, ಸರ್ವೆ ನಂಬರ್ ತಪ್ಪು ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ. 3A ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಸರ್ವೆ ನಂಬರ್, 3D ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಸರ್ವೆ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀವಿ. Only in the award the survey number was mentioned as wrong.
ಶಾರ್ಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಜಾಸ್ತಿ ಬೇಡ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಐ ವಿಲ್ ಗೆಟ್
And
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
that
ಫ್ರಮ್
this
ದಿ
thing has
ಪಾರ್ಟಿ.
also been rectified and that was intimated to the petitioner. ಈಗ ಈ ಒಂದು ಸ್ಟೇ ಆರ್ಡರ್ ಇಂದ the entire developmental activities is taken a stop. I also got videos to show that where the passerbys are been revolting to pay the toll amount.
You're not taking into discussion.
And notice toltala Swami, despite giving the notice. That's the reason by an affixure by way of an affixure will serve the notice. The ring page 15 may kindly be seen.
What is it you sought to acquire?
Please, my lord, sir, I've just produced a 3A notification, 3D notification. The
Now
issue-
come to Annexure D, page number 50.
15 of the compilation, my lords.
There, writ petition.
Writ petition, writ petition. Fifteen is your sale deed, my lords.
50.
50.
Yeah. ನಿಮ್ಮಿದ್ರಲ್ಲೇನ್ರಿ
50 is the building.
ನಮ್ದ್ರಾಗ
Nim petition. 50 is their building, my lords. The photograph of the property in question. This is the same property. This is the same property. Please, my lords.
Sought to acquire this.
We sought to acquire 3D notification and 3A notification only were mentioned as the correct survey number. If my document, the compilation of the documents, what I produce, if my lordship could.
Can't leave this property and develop, huh?
Please, my lords.
And you leave this property and develop?
Illa Swami, because that entire survey number, the stretch of land is sought to be acquired. So I can't single out this one particular property and carry out of the development. Because this is abutting in middle of the highway, the projected highway. In page 2 of the compilation, what I've produced before this honorable court may see, my lords.
Opposite ಏನಿದೆ?
Opposite ಏನಿದೆ? Property opposite ಏನಿದೆ?
ರೋಡ್ ಅಷ್ಟೇ.
It's road.
Right. Opposite of ನಿಮ್ ಎದುರುಗಡೆ ಏನಿದೆ ರೀ ರೋಡ್ ಆದ್ಮೇಲೆ?
Other side of
Other side of the road, what is there?
other side. Building road ಗೆ face ಆಗ್ತಾ ಇದೆ.
ಹೌದು.
Other side ಏನಿದೆ?
ಖಾಲಿ ಇದೆ ಅದು ಜಾಗ. ಟೀ ಶಾಪ್ಗಳಿದಾವೆ. ನನಗೂ ಅಷ್ಟು ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಸುಮ್ನೆ ಏನು ಹೇಳೋದ್ ಬೇಡ. ತಿಳ್ಕೊಂಡು ಅಲ್ಲಿ ಟೋಪೋಗ್ರಫಿ ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು ಸುಮ್ನೆ. ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಮೇಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಸಾಲ ಡೆವಲಪ್ ಆಗಿದೆಯಪ್ಪ. If other side is vacant, can't you acquire there, shift the alignment a bit?
Alignment agala Swami, because this is the current highway. Opposite, my instruction says is that there is a highway that's been coming. So with this also needs to be for the wide. This
My
property is
submission
also
is
been
that, my
required for
lord,
the widening of the highway, man.
after
Yes,
filing
Lord.
this, after filing
And
this
my lord,
petition, my lord,
another condition, even on the maintenance of the petition is, they have not challenged the acquisition.
Okay, which is this road?
Please, my lords.
Which is this road?
This is NH48. That notification, Tumkur Nelmangla, NH48.
Nelmangla ಆಗಲೇ ಡಬಲ್ ರೋಡ್ ಇದೆಯಲ್ಲ ಪೂರ್ತಿ.
Illa Swami, Nelmangla, there is Nelmangla, as soon as you enter the Nelmangla, that road that is just going through the Tumkur, there the development has been stalled, widening. And that is one of the reasons where all the passerbys, actual users of the highway are protesting to pay the toll. If my lordship could permit, I can just also just show the certain videograph wherein there has been revolt that has been made in order to pay the toll. And this one particular stay order is creating riot amongst the entire project, my lords.
So there is no way that you can say this building is it?
Please, one other submission is, had the acquisition been challenged, we could have done something.
No, not on technicalities, I say.
Because that's all with all
not
regarding
standing
the
on
project
technicalities.
estimation.
See, we are looking at the holistic picture.
Please,
See, admittedly, they have put up construction over there. Of course, you will compensate them.
Compensation.
That's a different aspect
We are
altogether.
not denying the.
No,
compensation.
what,
Please, my lords,
I
because
mean,
if this one
the
particular.
question is, can you
No, my lords, because
extend
my
the highway?
instructions are that all the project, the layout map, the estimation, everything has been done.
That is different concept.
At this juncture, in order to save.
The court is asking you, can you extend the highway without demolishing the existing structure?
I already have explored the possibility and used all my good offices, my lords. My instructions are that it cannot be done because all the estimate, the drawing, the project report and everything has been laid down. And if this one particular building is being saved, my apprehension is that it should not save as a kind of a precedent where all the other petitions will also just come and approach the honorable court.
Okay. When do you want short date?
next week.
We'll have it on 13th.
Please, my lord.
13th.
Please, my lords, 13th, because there is quite a bit of pressure on us.
13th.
Have the stay order vacated.
My lord, 23rd, my lord.
ಇಲ್ಲ ಆಗಲ್ಲ.
20th, my lord.
13th will be a.
13 ಬನ್ನಿ.
13 ಬೇಡ, ಅದು
ಆಯ್ತು 12.
17ಕ್ಕೆ ಹಾಕೊಂಡ್ರಿ ಸರ್.
13 ಬೇಡ ಅಂದ್ರೆ 12.
17ಕ್ಕೆ I will get the
Hottest
instructions.
possible date, my lords,
Madam,
because
ನಮ್ಮ
23rd.
ಪಾರ್ಟಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನು ಅಂದ್ರೆ ಈ ಹೋಟ್ಲ್ ಇದೆಯಲ್ಲ ಎಡ್ಜ್ ತಕ್ಕ ಬೇರೆ ಇದೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲಿಂದ ತಕ್ಕನೇ ರೋಡ್ ಬರೋದು, ಈ ಬಿಲ್ಡಿಂಗ್ ಬಿಡ್ಬೋದು ಅವ್ರು. ನಾವಾಗ ಅವ್ರಿಗೆ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದೀವಿ, ಕರ್ಕೊಂಬಂದು ತೋರಿಸಿದೀವಿ, ಅವರು ಬಂದವ್ರೆ ಇನ್ಸ್ಪೆಕ್ಟರ್. ಇಲ್ಲ ನೀನ್ ಕೋರ್ಟ್ಗೆ ಹೋಗಿದ್ಯಾ, ಕೋರ್ಟಲ್ಲೇ ಮಾಡ್ಕ ಅಂತಾರೆ.
So one, my lordship may take
requested some
cognizance of the
details.
fact that the acquisition process or
Mark ಮಾಡಿದ್ದಾರೆ ಬಂದು.
notice has not been challenged. The only this thing, all this while the contentions, all this while, then his survey number was not included in the notice. It shall demonstrate it, the saying that his survey number has been this thing. Only in the award, there has been a typographical mistake that has happened from our side. That has also been rectified and that has been intimated to the concerned party.
Okay, now listen, he is telling that till the edge of the road, you can extend the highway, you can leave the building, that's what he's saying.
That
Is it
to
true?
a due process of law has to be the thing. Acquisition a challenge madilla, and with a garb of filing this writ petition stating that his survey number has not been included, and coming with this particular prayer, irrespectful submission.
See, don't stand on legal technicalities.
Please,
I'm
my lords, I
asking
leave
you a
it to my
specific
lords,
question.
leave it to my lords, because the
Question of
entire,
not the
entire
question.
project is at stake, my lords.
See, not the question of leaving to the court. See, ultimately, we cannot substitute our wisdom with the wisdom of the National Highway Authority.
Please, my lords.
If the highway authorities say, yes, we require the road, we require the property for formation of the road, then the court will agree with that. Okay. The only thing the court is suggesting to you is, it is put forth by the petitioner that the road as proposed by you is sought to be extended till the edge of the hotel. Okay. And the building can be saved. That is the, that is the contention of the petitioner. Now, the ego of the officer concerned, mind you,
Please, my
not
lords.
the legalities.
Please, my lords, please, my lords.
The ego of the officer concerned. Many officers tend to have a big fat ego. Okay, the ego of the officer concerned should not result in an unwanted demolition of a well-constructed building, which can be otherwise put to use.
Please, my lords.
Just explore the possibility.
Please,
by
my
next
lords.
day
I
of-
shall seek instructions, my lords.
Put it to your officer about this. Okay,
Please, my lords.
let them take the land that is really required for
The laying of
formation of the road.
Please, my lords.
Let them not unnecessarily demolish the building.
Please, my lords.
See, if the building has to go, it will go. Can't be helped.
Please, my lords.
Okay, but at the same time, if the building can be saved by prohibiting parking in the front of it, by asking him to purchase the land which is to the side of the building, making the entrance from that side and putting his parking over there. If you can do it, let him do it.
Please, my- I shall
That's
seek
the
instructions.
only endeavor.
Please, my lords, please, my lords.
But ultimately, you will have to say scientifically what is required.
Please, my lords. It may be, the matter may be called on 13th, my lord. I shall explore the
Please,
instructions. I shall have.
Once it on 17th,
Please, my
we'll
lord.
have it on 17th.
As convenient to this
Okay,
honorable court.
at the request of petitioner, finally call on 17th. But explore this possibility.
Please, my lords. I shall try to attempt my good offices.
Okay, and this will be on YouTube also. You can show it to your officer, what the court has expressed.
Please, please, my lords. Please, my
This is also recorded.
Please, my
Like
lords.
you have recorded the proceeding.
I shall issue all my endeavors in exploring the good offices.
See, it's at the end of the day, make best use of the available opportunity.
Please.
And let the petitioners also be benefited.
Please, my lords. Please, my lords. Grateful.
interim audit to continue.
Interim order if any is extended till next date of hearing.
24 Rakshita DJ.
For petition, Your Honor, today morning we have given NOC Wakalat, Your Honor.
Filed the wakalat in this matter.
Filing a wakalat in this matter, please grant me 2 weeks time in this matter.
For the response, 2 and 3.
They want some
Respond.
time.
4 minutes.
Yes.
Short date, my lords, because
Oh,
they are
the
sitting on
request
an
of,
interim order.
Krishna, when do you want, Mr. Rajshekar?
2 weeks.
Right, ಒಂದು 10 ದಿವಸ ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡಿ.
Oblige. Interim order will be extended.
20. Interim order if any is extended till next date of hearing, needful by then. Amendment ಎಲ್ಲ ಮಾಡ್ಬೇಕು ಮಾಡಿ.
We'll do it.
May be taken as finally, my lords, because
It will be, don't worry. Registry is directed to show the name of free. ಯಾರ್ದು ಹೆಸರು ತೋರಿಸ್ಬೇಕು?
Yeah, I'm filing.
Yes, sir.
ಬರ್ಕೊಡಿ, ನಿಮ್ಮ ಹೆಸರು ಬರ್ಕೊಡ್ರಿ.
Raj.
ಬರ್ಕೊಡಿ, ಸರಿ. Registry is directed to show the name of free so and so as the advocate appearing for the petition.
grateful minutes.
25, Sanjeev BL. DP Vivekananda.
Opponent.
Just for tomorrow, my lord, there's some documents which I want to place on record. For the past, he's senior is on the way, my lord. I'm sorry, I can't.
Okay, the request of petition.
Tomorrow, my lord. Request for tomorrow, my lord.
Let's,
Next week.
Interim order.
That it is 1993 acquisition proceedings.
Okay.
Let several round of litigations. Let
ನಾಡ್ದು
how-
date ಕೊಡಿ.
2024 minutes.
Day after tomorrow.
Please.
Interim order, my lord.
Interim order if any is extended till
March
next.
of-
11, 26, Sandhya, you Prabhu.
I hear person number 2 and 4 in this
Application for
matter.
amendment. Lord, the amendment was with regard to the annexure, my lord, which. is
Madam,
already
we'll allow the
produced.
amendment.
I am filing objection to Milord.
Madam, we'll allow the amendment, you file objections to the main writ petition.
Milord, there are, Milord, they are asking for change, amendment in prayer, Milord. Now, we have already submitted before this honorable.
Madam, why don't you understand? It is their writ petition. They are seeking an amendment to the pleadings and the prayer made. I'll grant you time to file your objections for the amended writ petition. Let the amendment be carried out, no?
I leave it.
Let
to
the
your-
amendment be carried. Bunny,
But we
orders
will
on
file
IA
it
1
in
of
the
2024. I think you
registry.
file it in the registry.
Yes,
File it in the registry.
I'll file.
Orders on IA 1 of 2024. The aforementioned IA is filed to amend the writ petition, accepting the caution. The aforementioned IA is allowed, petitioner is permitted to carry out the necessary amendment and file amended writ petition within a period of 1 week from today. Full stop, 2 weeks. Further time is granted to the respondents to file objections to the amended writ petition.
Please, I'll serve the amended.
Yes.
Great.
27, Sundar Raman, MOE.
For the respondent.
Hmm.
You have sought for the instructions, my lord. To file objections, kindly 2 weeks time. maybe.
The request of,
This is in relation to the additional relinquishment that was sought for. We may file objection.
the request of respondent call on date could, or this a bit.
Interim order may be extended.
20, 29.
Order if any is extended till next date of hearing.
Great.
28, 29, Ajahn. 30, D.R. Ravishankar. Thirty.
We'll pass over, let's see. By D.R. Ravishankar designated as senior counsel. You will accept notice, Saravana Yaro idaralla. Who is from their office?
No. I am representing respondent number 5 in this matter. 30.
He's from his office only, no?
Yes, sir. Yes, sir.
There's a lot of delay in this matter. It was 89 acquisition notification. 2014, after passing of the award,
No, they will not come and,
please, ma'am. Please, ma'am.
they have no case on merits. Registry is directed to show the name of Free S. Saravana as the advocate appearing for the petitioner. Call on, 12ನೇ ತಾರೀಕು. 12.
12, 9.
What's up?
31, Vinod Prasad.
I appear for the respondent. This matter is pertaining to Nada Kempegowda layout. Challenge is to the acquisition proceeding. And division bench of this court has already rendered its judgment in writ appeal number 1783 of 2014, Your Lordship.
No notice is given to us, number one. And recent, their website, this land is shown as not notified area. 2007 preliminary notification, even prior to it, our father has expired. Immediately, we had given our intimation to all the authorities concerned. No notice given to us, even to our father. For that all, we have been.
You are the notified ಖಾತೆದಾರ?
ನಾವು ಅವ್ರಿಗೆ ಬರ್ದು ಕೊಟ್ಟಿದ್ದೀವಿ.
No, were you the notified ಖಾತೆದಾರ?
And.
ಏನ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹಾ?
ಏನ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ?
Pardon, my lord?
ಅಲ್ಲ ಬರ್ದ್ ಕೊಟ್ಟಿದೀವಿ ಅಂದ್ರಲ್ಲ, ಏನ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ? ಬರ್ದ್ ಕೊಟ್ಟಿದೀವಿ ಅಂದ್ರಲ್ಲ, ಏನ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ನಾವು ಈಗ ಆ ಲ್ಯಾಂಡ್ ಅನ್ನು ಈಗ ಹಂಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು, ಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾವು ಆಫ್ಟರ್ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್, neighboring adjoining land has been deleted. And now their website shows that this land has not notified area.
This land is?
Not notified area.
Have you filed your objections?
Objections.
File your objections.
But
The request of respondent, call next week, objections if any by then.
2 weeks, Your Lordship.
2 weeks.
The interim order may kindly be continued.
Interim order if any is extended till next date of hearing.
32 Ajjan, 33 KK Vasant.
ಎಷ್ಟಿದೆ ಲ್ಯಾಂಡ್ ಅದು ವಿಸ್ತೀರ್ಣ ಅನಂತ ಕೃಷ್ಣ ಅವರ? What is the extent of land?
1 acre 30 guntas.
Chirama 33 KK Vasant. Sachin BS. Sachin BS. Niva. The Murugesh Vichara teams.
The registry is directed to show the name of Sri Murugesh V. Charate, the advocate appearing for respondent number 2 and 3, and delete the name of Sri Sachin BS. Pass over. Let him come.
34 Ajjan, 35 Rakshita DJ.
In fact, Your Lordship, this is covered by the division bench judgment of this court. I got a copy of that order. Then I took time to verify and make.
Pass over, sir. Let them come. Pass over.
Thirty-six Rajeshwar PN.
Krishna.
Three for the respondent.
7 years cross, no award is made. 27 years since the final notification, no award is made, my lords. And this land is also not utilized. We asked for giving up 3 acres of land. They say under that scheme, my lords, they'll give only 32,000 square feet. Challenge the notification in respect of 3 acres of land, my lords. Preliminary notification is of the year 1994. Final notification is 1995. Admittedly, award not made, my lords.
My lords, beg to appear on behalf of the respondent KDB in this matter, my lords.
Yes, Shashi.
Well, in this matter, first of all, the petition is not maintainable, challenge the acquisition because it's a subsequent purchaser, my lords. Second point, well, acquisition was challenged and it was already dismissed, my lords, by Annexure E. Third point is, my lords, insofar as award is not passed because as per the policy, as against 3 acres, he has taken 32,343 as alternative land. So once he has already taken alternative land, as against 3 acres, the question of passing once again an award does not arise, my lords. Either we have to pass an award or give him an alternative land. He has accepted an alternative land in the form of compensation. Once he has taken what we do with our land is none of his concern, my lords.
Okay.
This is the short point.
This is the short point. Now, you come to your prayer.
The petitioner's prayer, my lords.
No, I'm asking the petitioner himself.
Please.
Let's declare the acquisition proceedings in respect of 1 acre, 29.
It's not 3 acres, it's 1 acre, 29 guntas.
Yes, my lords. 1 acre, out of that, my lords, they have utilized 1 acre, 10 guntas of land, my lords. So I am saying at least that balance land you give to me, I will not ask compensation for the land that you have already taken over.
No, he says alternate as land has been granted.
That is pursuant to the interim order of my lords. I have challenged that resolution. Pursuant to my lord's interim order, I have taken that property, my lords.
Which property?
That 32,000 square feet of area.
Hmm.
Pursuant to my lord's interim order, I have taken, my lords.
What is the interim order in this case? Kodile?
Subject to.
When was the interim order passed?
Lords,
My
it
lord,
was
interim
passed
order
on
was,
22/8/2022, my lords. Sorry, my lords. 13/12/2022.
No, Mr. Rajeshwar,
My
look
lords.
at your prayer.
Please, my lords.
Incapable execution and enforcement. You are not asked for setting aside the preliminary and petition.
I sought for a declaration that in view of the lapse of time, not making an award, that's incapable of execution, it has lapsed. Those notifications have lapsed.
Okay, award under the new act. New act is applicable to you, na?
Because
For
this is a
passing the award.
pre-2013 notification, so it may not apply.
It may not apply. Okay, under
Because that
the,
issue is pending before the division bench.
under the old act.
There's no time frame, my lords,
Old act.
within which they have to make an award under the act. Under the
Hmm.
KAD Act, there's no time frame.
Hmm.
But my lords, I have produced one judgment of the single judge, my lords, and I also have a division bench judgment which says that notwithstanding the land standing to be vested under 28(5), if the award is not made for a substantial period of time, the acquisition lapses.
When was the land notified?
Lords, 1994, my lords, preliminary notification, 15/7/1994.
Final notification?
Final notification is 20th September 1995.
No award.
He
No.
purchased the property on 10th July 2007.
How do you overcome subsequent purchaser?
Lords, the question is, my lords, they have not taken possession. They have not utilized it. They have not developed it. They say that this land is not usable.
See, possession barala, final notification agatla, land vests with the government, KDB.
For the acquisition to be complete, my lords, possession is to be taken.
Under
Otherwise, acquisition will not
KD,
be complete. Process will not be complete.
under KD automatically land vests with the
Land
government.
vesting is one thing, my lords. Vesting is one thing. But if possession is not taken, my lords, and award is not made, acquisition proceedings are inconclusive.
Award is not made, yes, acquisition proceedings is inconclusive, no
Yes,
two words about it.
Yes, therefore, my lords have said, sought the prayer, declare that this is not capable of
No,
enforcement.
but how you can overcome the subsequent purchaser embargo?
Lords, what if it were to be a person who is the owner of the property who is notified, my lords, what benefits he can get? The benefit he can also transfer.
It's
it.
only with regard to compensation, the subsequent purchaser is entitled to. See, that's what Supreme Court.
Therefore,
judgment
my lords,
says.
I said out of 3 acres of land, I am not insisting for 1 acre 10 quotas where you have already formed a road. I will not claim compensation for that. Remaining land you leave free of cost.
See, that is, that bargain cannot be enforced by the court. That your proposal for the bargain cannot be enforced by the court. See, the thing is, your 1 acre 29 guntas of land was acquired by a notification dated in the year 1995. In the year 2007, you purchased.
Yes.
So according to Supreme Court judgment, kodre ada. Supreme Court judgment kodre.
My lord, I have two citations.
What officer? Supreme Court judgment ಕೊಟ್ರಿ ಅದು that subsequent purchaser does not have a right. ಕೊಟ್ಟಿದ್ನಲ್ಲ ನಾನು.
That is my lord.
According to Supreme Court, see, you are entitled only to the benefit of compensation as a subsequent purchaser.
Yes.
You do not have a right to Supreme Court ಕೊಡಿರಿ ಕೊಟ್ರಿ.
Amount of NCQs is daily.
2024, 20. Detailed judgment ಇತ್ತಲ್ಲ. CE 2019 10 SEC 299. You go through it.
Union of India.
It's very clear.
Shiv
So
Kumar
you are right.
versus
You
Union
lose
of
the
India.
right, you lose the right to challenge the acquisition.
I have not challenged, that's why Malas have not challenged the acquisition notification. I have
It's
not
all
sought
right.
for questioning it. That's why I saw declaration.
So whatever, you are entitled to compensation, the present day compensation. The best part would be if award has not been passed, take the developed land in lieu of it as per the ratio. You have prayed it in your interim prayer.
No, that's the interim prayer, that's granted without prejudice to the right man.
Correct. But what is the ratio that?
You cannot have the cake and eat it too, my lords. He say, give me this as per your board resolution,
Look,
give me
Shashi,
that
if,
also.
but for him being a subsequent purchaser, probably he had a good case on merits to challenge the
They have
acquisition.
challenged it and lost. Annexure E, landowner and he both have challenged it and lost the acquisition.
Annexure is
Annexure E.
again another similar writ petition for
No.
similar relief, or matter was remanded back.
No, you see, in so far as the petitioner is concerned, they have already lost at page number 49. Page 51 is relief sought for, my lords. Page 51 is challenges the acquisition. This court dismissed it, saying consider the representation. Representation has been considered and alternative land has been given. Now, having got this 32,000, it's become, I can say, greedy, my lords, to say that further bargain, if he gets, he gets. That's the whole approach, my lords. So therefore, the original landowner and the petitioner have lost the acquisition.
No, it's only a thing of remand. See, I'll tell you, you people should stand up and oppose remand.
Correct.
See, if it has to be remanded, the reason for remand has to be brought out.
Your lordship, the right, my lords.
Kindly come to the judgments at page 69. Man. A similar relief is granted. Confirmed by the division bench.
And this is a case of maintainability of the writ petition itself, my lords. As the lordship pointed out in Shiv Kumar versus Union of India 2019, as well as Godfrey Phillips, Supreme Court has clearly said subsequent purchaser cannot challenge the acquisition or the lapsing. The interim order is the nature of final order, my lord. He's already got the implemented the resolution as per this.
No, it is not in the, see, this judgment at annexure L.
That is not
It does
applicable.
not, it is not applicable because it does not pertain to subsequent purchaser.
Correct.
That's the problem. See, I only told no, but for you being a subsequent
Kindly have
purchaser,
it tomorrow, my lords. Manava Dharma judgment one is there. I will place.
he wants it tomorrow.
No
I'll call it
problem.
day after.
Please, my lord.
I will call it day after tomorrow, Mr. Shetty.
Please, my lord.
Yes, so the request of petitioner call on day after tomorrow, date for. Please. Judgment itಕೊಂಡ್ರಿ ಅಪ್ಪ ಇದು ಪದೇ ಪದೇ ಕೇಳ್ತೀನಿ. This particular judgment.
Grateful to my lord.
Yes.
37, Somshekhar Naidu, B.
But I appeal for the respondent. This matter, Kaushik wanted to dispose of last week because of the council.
For the respond number 3, my lord.
They are seeking for consent award. So I have made an agreement and issued a check. By that time, sister has filed a suit and got an injunction not to disperse. Now they have given a representation 2020 that has been settled. my lord. Now regarding paying that consent, there will not be any problem that time.
Look, you will, if no one is objecting, then,
Ali, third respondent, it appears by mistake they have made as a land army corporation. Actually, special deputy commissioner ಮಾಡ್ಬೇಕಿತ್ತು I think
KPLC has,
nothing.
they do not have any records with them, because only
ಯಾಕಂದ್ರೆ
they take action against the persons who encroach upon the government land and protect that land and by fencing it. Except that they don't have any other role to play so far as this payment of compensation and other.
Para 7 ಅಲ್ಲಿ ಅವರು third respondent special deputy commissioner ಅಂತಾರೆ. By mistake, they have made a Karnataka public land
okay,
corporation.
now you will consider and pass award, no, in
Yes,
favor,
yes.
consent award ಮಾಡ್ತೀರಿ.
ಅವ್ರು ಮಾಡಿದೀವಿ, but now because of the injunction order, my lord, now they have given representative that has been settled. So we'll consider, my lord, regarding payment of consent. That I think.
Yes, ಬನ್ನಿ.
The interest portion is applicable interest is 12% at least to be 12%. As similar with the
Consent,
other matters.
my lord, there is no interest on the consent amount, but however, an earlier writ petition, my lord, court has directed to pay in view of the delay by the revenue authorities, my lord, pay the 9% interest from the date of taking possession, my lord.
In accordance with law ಅಂತ ಹೇಳ್ತೀನಿ
Yes,
ಅಷ್ಟೇ,
yes.
ಬೇರೆ ಏನು ಹೇಳಲ್ಲ.
And similar matters in the same notification, 12% has been awarded by
ಇಲ್ಲ, ಅದೇ-
this honorable court.
No, my lord. This matter, there is a direction, my lord.
I will supply the
Date
copy of that. It has been already, they have been challenged it, the honorable, in appeal matters also, it has been held that 12% is the applicable interest, my lord.
So they will pass the consent award in accordance with law. If you are
Yes.
aggrieved by it, challenge it, that's all.
Num court ಅಲ್ಲಿ it has been passed, my lord.
Consent award,
Recently,
question
very
of
recently,
interest, my lord.
12%.
ಕುಡಿಯೋದು ಏನು 12%, ಕುಡಿಯೋದು. ಇಸ್ಕೊಡಿ. ಎಲ್ಲಿದೆ 12%?
15, page 15, my lord. Page para 9. Page number 15, para 9. Para 9, para 9 ಅಂತ. Page number 16, para 13. It is connected with other matters. 12% is awarded by. Similar notification is the 12% as
But
stated.
here in this petitioner's case, my lord, they have produced that copy judgment. Court had directed to pay 9% interest. Page number, lord, annexure
They'll
B.
say in accordance with laws.
Accordance with law, can-
That they will consider and pass for this. But the lands of the petition, the petitioners are said to be owners of
survey number 6/P15, measuring
certain lands situated in survey number
6/P15, P15,
survey number 6/P15 in
2 acre 35 guntas, my lord.
ಅದಲ್ಲ ಏನ್ ಬೇಡ in
Singasandra.
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 Singasandra,
Singanahಳ್ಳಿ village.
Singanahಳ್ಳಿ.
Singanahಳ್ಳಿ village,
sorry,
Singanahಳ್ಳಿ village,
Singanahಳ್ಳಿ.
Singsandra ಅಲ್ಲ, Singanahಳ್ಳಿ village,
Jala Hobli, Bangalore.
Chala
North,
Hobbli,
Bangalore North.
Bangalore North Taluk. Full stop. Their lands have been acquired for the purposes of KADB. Full stop. The petitioners requested passing of a consent award in respect of the land consent under section 29 clause 2, correct?
Correct.
Of KAD Act. Yeah, full stop. However, as there was a dispute as to ownership of the property concerned, comma, respondent number 2 passed a general award and he has deposited the same before the reference court, correct?
ಇಲ್ಲ, my lord, because of that suit, my lord, without the payment of consent award.
Okay. So the money is still with you.
Yes, yes.
Okay.
Earlier,
Yan banta? However, as there was a dispute.
right. Dispute settled.
And he has deposited better, has passed the general award. Huh? Full stop. The money is not paid to any of the parties concerned.
General award has been modified, my lord. It is awarded as a.
Full stop.
62
Agreed by the same, the present writ petition is filed. Huh? Full stop. In the course of the arguments, it is submitted, next para. In the course of the arguments, it is submitted by the petitioner that the dispute has been resolved between the parties. And petitioners are entitled to receive
62 lakh per acre.
receive the compensation exclusively for the lands acquired. Exclusively for the lands acquired. Full stop. Hence it is prayed that second respondent SLAO may be directed to pass a consent award. Full stop. It is also prayed that interest be paid on the consent award as the money has not been deposited before the reference court. Full stop. Next para. The counsel for respondent number 2 upon instruction submits that if the petitioners were to produce all the relevant particulars showing that they are the absolute owner of the property concerned and that the dispute has been resolved and the dispute pertaining to the property has been resolved and they alone are entitled to receive the compensation. The petitioners shall be paid the necessary compensation under section 29 clause 2 of KAD Act. Full stop. His submission is placed on record. Full stop. Hence the following order. Respondent number 2 is directed to compensate, to pass an award under section 29 clause 2 of KAD Act in respect of the lands which are the subject matter of the writ petition and pay the same along with due interest thereon, to the petitioner or petitioners.
Petitioner. Only part.
To the petitioner in accordance with law. Full stop. Next para. It is needless to state that in the event of petitioner failing to produce the relevant particulars to show that he is the sole owner of the property concerned and authorized to receive the compensation exclusively, respondent number 2 is at liberty to deposit the compensation amount along with due interest thereon as per the general award before the reference court in accordance with law. And not and in that event, compensation shall not be paid to the petitioner. That petition disposed of accordingly.
My lord, there is confusion. General award is previously it was 25. The later on in a writ orders it is directed as 62 lakhs per acre. It is the award passed to the all the.
Sir, in accordance with law, and you are always entitled to seek enhancement of.
Please.
If they don't pass a consent award, and if they pass a general award. See, this is the problem with lands in Jala Hubli. Especially P Barutala. Survey number P dash Barutala.
All the land.
Most dangerous.
That proceedings all terminated in this case.
Correct. One has to be very, very careful with regard to especially survey number P dash.
Entire extent was Goma land, they have stated to be grantees and claim.
Especially in the light of what has transpired with KIDB after, or rather the DCAC office in Bangalore, subsequent to 2006. That's terrible, terrible, terrible. ಇದು ಕನ್ನಡದಲ್ಲಿ ಗಾದೆ ಇದೆಲ್ಲ, ಯಾರ್ದೋ ಮದುವೆಲಿ ಉಂಡೋನೆ ಜಾಣೆ ಅಂತ. ಏನೋ ಅಷ್ಟೇ ಆಗಿರೋದು. RTC ಇಲ್ದಲೇ ಇರೋ ಕಡೆ RTC ಬಂತು, ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ರು. ಬೆಸ್ಟ್ ಪಾರ್ಟ್ P ಇದರಲ್ಲಿ 200 ಎಕರೆ ಇದ್ರೆ RTC ತಾಳೆ ಹಾಕಿದ್ರೆ 300 ಎಕರೆ ಬರುತ್ತೆ. ಏನೋ ಜೆನ್ಯೂನ್ ಗ್ರಾಂಟ್ ಆಗಿರೋರ್ಗೆ, ಜೆನ್ಯೂನ್ ಗ್ರಾಂಟ್ ಅಲ್ಲ, ನೀವು ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ತಂದು ತೋರಿಸಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನೋಟಿಸ್ಗಳು ಕೊಟ್ರು.
Same thing has been transferred in this matter. It is the matter is
ಅಲ್ಲಲ್ಲ ಸರ್, ದಿಸ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ.
In this case, entire
ಈ ಅಲ್ಲೋಲ ಕಲ್ಲೋಲ ಆಗೋಯ್ತು.
innocent persons are also suffering.
Then probably people want it that way. That's why it's happening. Yes, disposed of.
38 PS Mali Patil, K Krishna.
Petitioner is a teacher, my lords, both the state level and national award winner, my lords.
Objection not filed, my.
You want to file objection?
A date may be fixed, my lords. This is second round of litigation, my lords.
Another request of
Direction of-
respondents.
24th, my.
Call on
24th.
24th. Objections if any by the
39. Jay Jay.
ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಅಬ್ಜೆಕ್ಷನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಹಾಕೊಂಡ್ರೆ.
date ತಗೊಳ್ಳಿ.
Lords, what has happened is I had filed a writ petition. I am a purchaser who had purchased it in 2021, 2023 is a notification for previous sale. ಇದಕ್ಕೆ 2016 ಅಲ್ಲೇ purchase ಮಾಡೀನಿ ಈ ಸೈಟ್, ಸಣ್ಣ ಮನೆ ಇದೆ. What has happened is that my predecessor in title's name was being shown. When I filed the first writ petition, inadvertently this particular sale deed was not produced, and my lords, I didn't get an order. For the subsequent, for the previous one, there is an order. This one, my lords, is identical. My lords may see my lords may see the orders of this honorable court at Annexure G, page 61. Same acquisition, same notification. ಪಕ್ಕದ ಪ್ರಾಪರ್ಟಿಗಳು ಒಂದಕ್ಕೆ ನಾನು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ತೆ, ಇನ್ನೊಂದಕ್ಕೆ ಅದರಲ್ಲೇ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ಬೋದಾಗಿತ್ತು, ಮಿಸ್ ಆಗ್ಬಿಡ್ತು ಸ್ವಾಮಿ. ನಾವು
He wants to raise the same objections.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ವೀಕ್
He wants a date for that.
ನೆಕ್ಸ್ಟ್
Yes,
ವೀಕ್
so
ಅಲ್ಲ
the request of response, call on date ತಗೊಳ್ಳಿ.
ಎಷ್ಟು 9th ಅಲ್ಲ 18th.
18 ಬೇಡ ಸ್ವಾಮಿ, 19 this one.
19.
40, number 40.
My lords, 40, my lords, I appear for the land loser, my lords. It's a situation, my lords, where 4 acres, 8 guntas is acquired, my lords. My lords, insofar as 17 guntas is concerned, my lords, it was actually a karab. But my lords, when I obtain, even in the RTC, it is showing a karab. But when I obtain conversion, my lords, in the conversion order by mistake, it is shown as B karab. Now they do a survey. When they do a survey, my lords, the ADLR has said that no, conversion order only B karab and ತೋರಿಸಿದೆ. Therefore, even though it is a karab, I will consider it as B karab. So, my lords, for 17 guntas, my lords, I have not been given compensation. My request, my lords, is subject to what the respondents would say. My lords, if ADRL can do a survey independent of the conversion order, my lords, conversion order is not the basis of anything. ADLR has to go on the land revenue records. Does a inspection on the basis of survey on the basis of land revenue records?
Show your title deeds to show that you are the owner of the property.
Yes, my lords. My lords, may kindly see annexure B1, sale deed, my lords. Annexure B1 and B3, my lords, are the two sale deeds.
Direct you to consider and pass orders.
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
And ಇದರಲ್ಲಿ they're challenging the conversion order of 2010. Only one clause in the conversion order. It's an appeal provision under section 49.
It's okay if it is, that is the only thing.
Allah, if it is B Kharab land,
Lord,
he-
B Karab
he
land
has to
cannot
make a
be.
claim.
Even, my lord, if it's a Karab land, even if it's a Karab land, my lord, that has to be granted, my lord, as per, my lord, the land grant rules. As per rule 21, my lord, class 1, class 2, my lord, of the KLR Act rules, Lord, if it is A Karab or B Karab, Lord, if it is classified as A crop, Lord, land has to be granted from, Lord, the appropriate authority. Lord,
No. See, if it is A crop, it's a private property. If it is B
No.
crop, it's a government land.
Lord, B crop is government land. Even if it's A crop land, my Lord, he has to make an application, my Lord, for granting. Illandre barodilla, sir.
Both, my lord.
Not grant, is he not the owner of the property?
Lord, A crop, my Lord, he can cultivate it. There's no dispute about it.
No, not like that.
Not
He
eligible
can't
for
cultivate.
Compensation, in so far as compensation is concerned, my Lord,
No,
yeah,
no.
Lord, land has.
How did he become the owner of the property?
Lord,
How did he become the owner of the property?
Lord,
See,
rules, my
unless
Lord.
there is a grant, he does not become the owner of the property.
Like
See, if it is a-
usually ಆಗಿರುತ್ತೆ ಸ್ವಾಮಿ ಒಂದು 10
No,
ಎಕರೆ
no,
ಇದ್ರೆ
no,
ಅದ್ರಲ್ಲಿ
Pradeep,
ಖರಾಬ್
but-
ಲ್ಯಾಂಡ್ ಇದ್ರೆ.
No, it's like this. Ownership is different. Class of land is different altogether.
True, my Lord.
Ownership, if it's a government land or a government land or a land vested with the government due to land reforms or whatever, and if it has to be given to somebody else, it has to be by way of grant. Then that person becomes the owner of the property. It doesn't matter whether the land is arable or unarable Kharab land. Okay. To claim ownership over the land, he has to show that he is the owner of the property. ಅದು ಹಿಡುವಳಿ ಜಮೀನಾಗಿದ್ರೆ ತಲಾಂತರದಿಂದ ಬಂದಿರುತ್ತಾ question of grant does not arise. Okay.
The granted land.
To claim compensation over a piece of land, the person has to prove his ownership. Kharab does not mean the entire, he is not entitled to compensation. Kharab means the land is not fit for cultivation. Okay. That's the reason why it is not assessed for tax revenue. If by his efforts, if he can bring it under cultivation, then it becomes fit for cultivation.
Yes.
And this Kharab unarable land can be a government land where the natural stream flows. It is not owned by anybody.
ಇದರಲ್ಲಿ ಟ್ಯಾಂಕ್ ಅಂತ ತೋರಿಸಿ.
Okay.
ಒಂದು ಆಕಾರ ಬಂದ್ಬಿಟ್ಟು shows
Or it may be some rocks lying under his ownership, which he cannot till because there are rocks and it is not just soil.
That is, my Lord,
Okay.
B crop.
That is A Kharab. See, that rocks can be A Kharab or B Kharab. If it is a water stream, normally it is B Kharab. Normally, it is not that he can't own it or something like that. Okay, that's how the lands have been classified earlier.
ಇದರಲ್ಲಿ ಟ್ಯಾಂಕ್ ಅಂತ ತೋರಿಸಿ.
My lords,
ಇದನ್ನಲ್ಲಿ
RTC ಲಿ A ಖರಾಬ್ ಅಂತ ತೋರಿಸುತ್ತೆ.
Now the point is, he should, irrespective of what is shown in the RTC, RTC is not
Ultimate, not record.
title deeds. To claim compensation, he has to produce the title deeds, undisputed title deeds. Now the title deeds should show that he is the owner of the property. It doesn't matter whether it is a land which can be tilled or a Kharab land. He has to show his ownership. If it is a Kharab, then in that event, he gets compensation. If it is B Kharab, he doesn't get compensation.
kindly see the conversion order at page 50.
If it is a Kharab, he has to produce title deeds. Now, what did the RTC say?
RTC says A kharaab, my lords. Page 85, my lords, RTC says A.
If you want to file your objections, file your objections.
They've
I
filed,
filed my
they've filed.
objections.
Government
But, kindly see the conversion order at page 56. Annexure D. ಇದನ್ನಲ್ಲಿ on 11.
Okay, with regard to Annexure D, he has got an alternative remedy, huh?
My lords,
Yes.
my submission is this, my
Kindly
lords.
see clause 7. That at page 57. ಕ್ಲಾಸ್ 7 ಇದೆ ಅದರಲ್ಲಿ ಈ ಜಮೀನಿಗೆ ತಾಕು ಭೂ ಖರಾಬ್ ಜಮೀನು ಇದ್ದಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 1964 ಕಲಂ 67ರಂತೆ ಸರ್ಕಾರದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸತಕ್ಕದ್ದು. ಕೂಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11ರಲ್ಲಿ 3 ಗುಂಟೆ ಅಧಿಕ ವಿದ್ಯುತ್ ತಂತಿ ಮಾರ್ಗ ಹಾದು ಹೋಗುತ್ತಿರುತ್ತದೆ ಹಾಗೂ 5 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನು ಬಿ ಖರಾಬ್ ಆಗಿದ್ದು ಸದರಿ ಬಿ ಖರಾಬ್ ಜಮೀನು ಭೂ
Okay, I'll do one thing. I'll remind it, you just consider it in accordance with.
ADLR ಗೆ remind ಮಾಡ್ಬೇಕು ಸುಮ್ಮನೆ. ADLR has to
Remind
conduct the
ಬರಲ್ಲ.
survey.
No, it's not the question of conducting the survey.
No, because he has
The
been
question
paid
of granting you compensation.
Swami, Ade, what has happened
Like
is,
he has
I'll just
been paid
explain.
compensation in
Sir,
respect of
just
the
1 minute. My lords may kindly see annexure M for a minute. Annexure M at page 85 for a minute.
Now, Ajay, see, at the end of the day, your case is you are entitled to compensation. Right? You will make the necessary observation and remind it to Special Land Acquisition Officer.
So the difficulty there is, I'll just explain my difficulty. My lords, RTC and all our revenue documents will show that it is A Kharab. Conversion order will show it is B Kharab. So they will say you get the conversion order set aside. Now the difficulty here is this: I cannot get the conversion order set aside. I have to get a portion of the conversion order set aside. Even to get that portion set aside, even if I go before the Karnataka cabinet, they will say what document do we, how are we to decide whether the DC is wrong or not, insofar as clause number 7 is concerned. Therefore, they will say in the fitness of things, ADLR should do it. You make an application before the ADLR, let the ADLR examine and say whether that 17 guntas is actually A Kharab or B Kharab. Then basis that, we can proceed and we can look at conversion. Now the
ADLR can say whether it's Kharab land or not. He cannot say whether it's A Kharab or B Kharab. ADLR can only say whether it is Kharab land or not. That's all. ADLR cannot decide as to ownership of the property.
No, ownership alvela. What I'm saying is,
see, there is no difference in the classification of land when it comes to A Kharab or B Kharab. Kharab means it's an unheirable land. That's all. Okay.
If I can just persuade my lords to see one judgment on this aspect. Why I'm saying that is because in an identical situation, what has happened is that insofar as A Kharab is concerned, my lords have said, A Kharab, you are entitled to compensation. Even if B Kharab is coming within the larger granted area to you, you are not entitled to compensation. So therefore, my lords, if I'm A Kharab, if it is classified as A Kharab, how it is to be looked into the judgment?
Who has to decide whether it's A Kharab or B Kharab?
ADLR. Only the ADLR.
How can he decide as to the title of the property?
Not title. That is the thing. If I can just, my lords, A Kharab or B Kharab is a revenue classification of a portion of the land. That's all. It's a revenue classification. It is not on title at all. What my lords have
it is on title.
My lords, A Kharab, even if it is A Kharab, my lords have held that you are entitled to compensation if it is A Kharab. My lords have not held that A Kharab will always belong, A Kharab will not belong to it will not belong to that person by itself.
You just show it. Rules, Elworth, A Kharab, B Kharab, Kudil.
Rule 21, 3.
21 of?
Rule 21 of 21
ALR rules.
Classification anta Rule 21.
Nodi, 21 Nodi.
Sorry.
Of Karnataka land revenue rules.
Yes.
The
purpose of assessment, all land shall be classified with respect to their respective productive qualities.
Pause for a minute.
Sorry, clause 2.
Pause for a minute, I said.
Sorry.
For the purposes of assessment, all land shall be classed with respect to their productive qualities. Okay, it is not with regard to title first.
Yes.
Okay, then read.
The number of classes and their relative values reckoned in annas, 16 annas, 100% classification shall be under the orders of the Commissioner for Survey, Settlement and Land Records with reference to the circumstances of different tracts of the state to which the survey extends and to the nature of cultivation. And the classification result shall be recorded in the following books and forms. 1. Prati book. 2.
Yes, you can skip that.
Sorry, minutes.
You can skip that. Come to
yes, I'll come to 2 minutes. During the process of classification, land included as unheirable shall be treated as potkarab. Potkarab may be classified as follows.
Pause for a minute. Yes. So, it is not on ownership. It is on classification is done on whether the land is heirable or not.
Yes.
Okay. If the land is heirable, then it is taxed.
Yes.
If the land is not heirable, that is, if it cannot be cultivated, then it will be considered as potkarab. Putkarab. Okay.
Yes.
And putkarab is classified into A and B.
Yes.
Now come to A, now come to B.
Classified as follows: that which is unfit for agriculture at the time of survey, including farm buildings or threshing floors of the holder. B, that which
is important is farm building, including the farm building or the threshing floors of the holder.
Yes.
That is important. Yes.
B, that which is not assessed because it is one, it is reserved or assigned for public purpose.
That means owner is not the owner.
Yes, owner is not the owner. Two, it is occupied by a road or recognized footpath or by a tank or stream used by persons other than the holders for irrigation, drinking or domestic purposes. Two, used as a burial ground or cremation ground. Well, it should be three, sorry, assigned for village potteries.
So that means to say a land which is not arable
Yes,
becomes Kharab land.
Yes.
Of that, which is owned by the owner is A Kharab.
Yes.
Which is not owned by the owner is
Yes.
B Kharab.
Yes.
The question of ADLR classifying the land as A Kharab or B Kharab does not arise. He only classifies whether it is Kharab land or not. And on the face of it, if the title is there with the owner, it gets classified as A Kharab. If the title is not with the owner, if it is for public purpose, the land to be utilized, it gets classified as B Kharab. Okay. Now, when the land is acquired, you are required to show the title deeds pertaining to the land. Irrespective of revenue documents, the title deeds will be verified. And if the title deeds show that you are the owner of A Kharab land, you will be entitled to compensation. If you fail to show you are the owner of A Kharab land, then you are not entitled to compensation. Then you will have to initiate appropriate proceedings against the acquiring authority to claim compensation towards the land acquired. That is the procedure.
So I go down, my lords, if my lords were to record it in that manner, my lords, then I'll produce the title deeds before them and then they
Yes,
can.
I will remind you to SLA.
He may not be in a position to take a decision as to who is the owner of the land.
No, if I produce.
If you cannot, if the state is making a claim, see, there can be only two persons making a claim over here. It's either the petitioner or the state.
Usually state.
If the state is making a claim, deposit before the.
Lord, you Lordship kindly, my lord, say that my lord will deposit. Let my lord notices be issued to my lord petitioners and my lord. Allah, zero word. Zero word
can be.
Zero word Madi. If my lord he wins, my lord, then zero word Madi.
Yes, reference court, let it decide if there is a dispute.
You may have to establish it. I'll just point out one or two things. Originally, when I was reading clause 7, the last sentence in that, ಈ ಖರಾಬಿನ ವಿಸ್ತೀರ್ಣದ ಹಕ್ಕು ಯಾವಾಗಲೂ ಸರ್ಕಾರಕ್ಕೆ ಸೇರಿರುತ್ತದೆ. ತಹಸೀಲ್ದಾರ್ ಅವರು ಈ ಬಾಬ್ತು RTC ಯಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದಿಸತಕ್ಕದ್ದು. ಅವರು ಅದು ಮಾಡಿಲ್ಲ, ಹಾಗಾಗಿ ಅದು ಏ ಖರಾಬ್ ಅಂತ ತೋರಿಸ್ತಾರೆ RTC ನಲ್ಲಿ. Which my lawyer.
Correct. That's the reason why I'm not setting aside anything.
No,
it's a title dispute. The land has been acquired. You pass the award and deposit before the court. Whether it is zero award or the compensation, it's left to you. The person interested will go and appear before the reference court and they will claim compensation. That is the only option left. What?
Okay, man.
That's the way it is.
Zero award and what's good. Zero award or 10% of the total award on the circular 2004.
The dispute is
17 guntas.
303
Square meters.
Where is 17 guntas in?
That is the thing, my lords. In the conversion order, it is not shown. Kindly see the RTC at annexure M, my lords. RTC at annexure M. In the RTC, 17 guntas is shown as A Kharab. So for the entire A Kharab, they have not. My case is that for the entire A Gavar, 17 guntas.
This is in survey number 11.
There is a
Also,
survey number shown, my lordship.
Survey number 11.
But that is B Kharab. Subsequently, my lordship, that is clarified on B Kharab. Entire survey number 11 and 17 guntas is B Kharab.
That's okay. There is a dispute. Survey number 11.
11. How?
Survey number 11 of?
Hudi village. My lords, Hudi village, my lords.
Pudi village.
Yes, my lords.
Yes.
ಅದಕ್ಕೆ ಮಾತ್ರ
ಅಷ್ಟೇ ಅಷ್ಟೇ ಡಿಸ್ಪ್ಯೂಟ್
Total extent is 4 acre 8 guntas, my lords.
notification
Money. Certain lands in survey number 11 of
just one clarification.
Lord,
What is
only-
acquired is only 303 square meters. Out of, he may be claiming 17 guntas, but what is acquired is only 303, which probably translates to about 3 guntas.
that's okay. That's why I'm telling certain lands.
The reference can only be in respect of.
No, that's why I'm telling certain lands. I'm not mentioning the exact.
I just wanted to clarify it in the beginning itself because
Yeah.
just in case,
Certain lands in survey number 11 of Pudi village has been acquired for the purposes of
Lord, Metro.
second
Lord.
respondent, Bangalore Metro Rail Corporation Limited, huh? In brackets BMRCL. Full stop. On the ground that the land acquired forms part of B Karab land, correct ಏನ್ರಿ?
Yes,
ಅವನಿಗೇನು ಕಾಂಪೋಸಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ ತಾನೆ?
ಕೊಟ್ಟಿಲ್ಲ.
The land
in
acquired on
respect
the
of the
ground.
land ಕೊಟ್ಟಿಲ್ಲ.
ಸರಿಯಾಗಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ ಡಿಕ್ಟೇಷನ್. Actually ತಪ್ಪಿದ್ರೆ ಕರೆಕ್ಟ್ ಮಾಡಿ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತಿರೋದು.
Just clarify, in respect of the land Kotila, he had some building for which we have paid.
Okay, but
Structure.
just hear the dictation. If there is anything erroneous on the facts, you bring it to my notice. We'll correct it. ಏನ್ ಬಂತು? On the ground that the land acquired, the lands acquired are part of B Karab land, comma, in other words, land belonging to the government, comma, no award has been passed. Full stop. The petitioner contending that the lands acquired are not B Karab but A Karab, single inverted comma, A another, A Karab, and he is entitled to compensation, has filed the instant writ petition. Huh? Full stop.
Rule 21, Lord, 2. Rule 21, 2.
ಎಲ್ರಿ ಅದ?
Rule 20.
ತಗೊಳ್ಳಿ ಒಂಚೂರು. Full stop. Next para. Agricultural land, comma, for the purposes of assessment, comma, are classified with respect to their productive qualities. Full stop. When the land is unarable, UNARABLE. When the land is unarable, it is treated as single inverted comma, Port Kharab. POT space Kharab, KHARAB. Full stop. The said Port Kharab land can be owned by a private individual, and under the said circumstances, it will be classified as A Karab, A single inverted comma, and it may not be owned by anybody, and under the said circumstances, it will be classified as B Karab, single inverted comma B. Full stop. Next para. In the instant case, admittedly, certain lands in survey number 11 of Pudi village has been acquired. Full stop. The petitioner is claiming ownership over the same, contending that the land is a karab, whereas the respondents contend that the land is B karab and the same is not owned by the petitioners.
As per the my lord Akarban.
Goes without saying, I say.
Please.
Full stop. Next para. Under the said circumstances, the petitioner is always at liberty to make a claim before the third respondent, fourth respondent, special land acquisition officer. And upon verification of the same, if he comes to the conclusion, what is the remedy open?
My lords, my lords have held that, no.
What is the remedy open?
Lord,
If
if it's
he comes to the conclusion it's a state property, what is the remedy open for him?
Lord, if it's
Reference court, my lords, I have to go to
reference code, my lord, will my lord
I have to
pass
go to-
0 award and my lord make reference. Then he has to, my lord, notice will be issued, he has to contest the matter there, my lord.
Now, should you necessarily make a 0 award? Under what provision of law?
Lord, usually, my lord, for the Karab land, we make, my lord, 0 award. Lord, if it's
No, under what provision of law?
Under the KID Act itself, my lords, under 29(1), it's
circular ಇದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
ಕೊಡಿ ಅದು.
ಅಲ್ಲ, ಈಗ
No, we'll put proper wordings. That's the reason I'm asking.
ಅದು ಈಗಿಲ್ಲ ಸ್ವಾಮಿ. Now I don't have, my lord, that copy.
Okay, what does it tell me? You pass 0 award, is it?
Lord, there's a government, my lord, circular. It
Ah.
says that, my lord, if my lord Karab land is acquired, my lord, we have to pass 0 award and my lord make a reference.
ಏನ್ ಬಂತ ಹೇಳಿ? That petitioner is indeed the owner of the property. He shall pay the compensation to the petitioner. Full stop. If he comes to if the SLAO is of the opinion that petitioner is not the owner of the property, then in that event, the matter shall be referred to the reference court. Then in that event, award will be passed in accordance with law and the matter will be referred to reference court. Reference court. And the petitioner is at liberty to establish his right over the property before the reference court and claim compensation. Full stop. Next para. In the incident case, the grievance of the petitioner is that his case has not at all been considered by respondent number 4, special land acquisition officer. Full stop. Next para. Hence the following order. Petitioner is given liberty to make necessary representation to fourth respondent, special land acquisition officer,
time frame.
enclosing all the necessary documents to show that he is the owner of the property that has been acquired. Next, upon receipt of such representation, respondent number 4 shall take a decision within a period of 3 months thereafter. And if he comes to the conclusion that the land the land is B Karab and B Karab, then in that event, reference shall be made to the reference court. Reference court. And upon such reference, petitioner is at liberty to prove his title before the reference court in accordance with law. And obtain necessary compensation if he succeeds.
ಅದರಲ್ಲಿ fourth respondent may be directed to Milord, Milord pass appropriate orders ಅಂತ ಮಾಡಿದ್ರೆ Milord it will comes ಬೇಕರ ಬೇಡ ಮತ್ತೆ ಅದು confusion. Make appropriate order Milord.
ಹೇಳಿದ್ನಲ್ಲ.
ಅಲ್ಲ ಹಂಗೆ ಹೇಳಿರೋದು. ಅಲ್ಲ ಬೇಕರ ಬಿದ್ರೆ ಮಾತ್ರ reference.
If he comes to the conclusion it is B corrupt, then he will make a reference to the reference court ಅಂತ ಹೇಳಿದ.
Milord, even in A case, A corrupt, Milord, land Milord, we Milord make reference. That's what Milord.
ಏನ್ ಬಂತ ಹೇಳ?
My lords,
Conclusion that if he comes to the conclusion that petitioner is not the owner of the property, appropriate reference will be made to the reference court, and the petitioner is given the liberty to approach the reference court and seek compensation in accordance with law upon establishing his title to the property consent.
Grateful.
41. Sheet number 41.
And for the
M. Srinivas
response-
Reddy.
ಅಲ್ಲ, ಇದರಲ್ಲಿ objection ಹಾಕ್ಬೇಕು. Recently of Milord entered appearance.
The request of respondent number 2 call after 2 weeks.
42. Manjunath Prasad HN.
Objections if any by then. Pass.
Madam, ಇದು 42 date ಹೋಗ್ಲಿ. ಇದರಲ್ಲಿ ಕೂಡ objection.
ಇದು same order.
43. Srinivas V.
In this case, I'm petitioner in this case. Responding number 3 to 5, my lord. I find my objections. 1 week time may be.
My lord, last time, same submission was made and your lordship have imposed a cost of rupees 500 with a direction to file it, failing which he will be imposed with a cost of 5,000 rupees. That was the, his other colleague came
Yes, I admit, my lord, I admit. But.
and he has not paid the cost also.
1 week, my lord, I will file my
My
objection.
lord, it's a writ of mandamus, my lord. Land have been acquired in the year 2011. I have executed the relinquishment date in the year
Cost
2011.
ಕಟ್ಟಿದ್ರೇನ್ರಿ?
ಕಟ್ಬಿಡ್ತೀನಿ. Next week ಅಲ್ಲಿ.
My lord, annexure D.
Despite of imposing a cost of rupees 500 on the last date of occasion for not filing objection statement. Respondents 3 to 5 again praise for time. ಕೊಡಿ 500 ರೂಪಾಯಿ. ಇದೆಯಾ ಜೇಬಲ್ ದುಡ್ಡ?
ಇದೆ.
ಅದು ಗೂಗಲ್ ಪೇ ಮಾಡ್ತೀರಾ? ಶ್ರೀನಿವಾಸ್ is high tech.
ನನಗೆ ಅವ್ರಿಗೆ 500 ರೂಪಾಯಿ ಕೊಡದೇ ಇದ್ರು ಬೇಡ.
ಅಲ್ಲ
Objection.
ಶ್ರೀನಿವಾಸ್ is high tech.
Paid ಅಂತ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ but they should have respect for everything, my lord.
I will
Because
file my
the
objection.
reason is, my lord, ಒಂದು mandamus ಗೆ ಇವ್ರು ಇಷ್ಟು objection ಮಾಡೋದೇನಿ. Land
ಏನ್
ಕಳ್ಕೊಂಡಿರೋ ನಾನು 2011 ಅಲ್ಲಿ.
I have sent for parawise remarks. File.
Finally, 1 week time is granted to the petitioner by imposing a cost of by imposing an additional cost of rupees 1,000 payable to the petitioner
ಅಲ್ಲ 5,000 ಇರ್ಲಿ ಸ್ವಾಮಿ. ಅವ್ರು ಕೊಡದೇ ಇದ್ರು ನಾನೇನು
by the next date of hearing. ಅದು respondent ಅಲ್ವಾ first ಏನಂತೆ finally 1 week time is granted to the respondent by imposing by next date of hearing. Call on next week correct date ಕೊಡಿ 17th. No further time, file your objections.
ಫೈನಲಿ ಇರ್ಲಿ. 44 Arjan. 45 P.V. Chandrasekhar. 44 Ajay Kumar M. 44 45
Appearing for the 45, I seek time to file my objections, my lords. I'm for the petition.
Which is your matter, sir?
45 ಅಲ್ಲ sir. 45, I pray for time to file my objections.
The request of respondent call after 2 weeks.
Date may
Call on date, call on ಮಾಡ್ಕೊಳ್ಳಿ.
24
Objections if any by then. Yes. Further hearing. Correct.
46 further hearing. Vishwanath check.
Lord, 46, last occasion, Lord, the government was directed to conduct, my lord, survey and submit report, my lord, but my lord, they did not go for the survey, it seems.
May I request, I came on 4th, waited at the spot from
Even, my lord,
10:30 to 4:30.
KDB
There
officials
was
was-
no, and I have also
39.
asked the councils and informed that my.
1 second.
Dates for survey by law. And also petitioner himself saw 1 week time to produce some documents.
Lord, now, my lord, in the 13/9/2024, my lord, survey, my lord, has been
Yesterday.
fixed. Notice has also been issued.
No.
Let him appear, my lord, on 13-9.
Your lordship, I am filing an affidavit and bringing the said facts to your lordship.
Sir,
Oh,
listen,
it's okay.
you need to understand one thing. It's your interest at the end of the day.
Yes, sir.
It's your interest which is involved at the end of the day.
I leave to your.
You have to extend maximum cooperation to the authorities
39
concerned.
Your lordship.
Just pointing a fingers towards them does not take you anywhere, sir.
No, I am only.
Okay.
I mean,
See, we are trying to find out if anything can be resolved. That's all.
yes, sir. I
See,
leave to your.
the dispute pertains to identifying your property.
Your lordship.
Because you are showing one property, they are telling your property is something different altogether.
Yes.
Now, that can, that if there is a dispute with regard to facts, this court in its exercise of Article 226 cannot decide.
No, your lordship, sir, have this.
Sir, listen to the court. Have
sir.
patience, sir.
Sir.
Okay, the whole idea is
To identify.
to identify your property first
Adjudicate.
and then ask them whether it can be left out of acquisition or it is a must for acquisition so that you will be duly compensated.
Yes.
Okay, this is the exercise that is being done. Either way, this is being done in your interest. You are required to cooperate with the authorities concerned rather than indulging in a blame game.
No, I am not blaming
Okay,
you.
and you have to understand they are not your rivals. They are the state. They are not concerned. You need to understand that. They don't have any personal interest over here. Okay, it's not that they are your neighbors where you file for an injunction suit and keep fighting every day. It's not like that. They won't have that kind of mentality. They're at the end of the day state officers. Okay, there is a method of seeing to it that things get done. Okay, let's see on.
And your lordship, this was considered since 2008 onwards by this honorable court in 4 writ petitions. And now your lordship, they have come up, your lordship may kindly consider, this honorable court consistently held my sale deed.
Sir, the order was passed saying that the survey shall be conducted in the presence of the petitioner and officers of KDB on 4th September 2024 at 11 AM. This was the order passed.
ಅದಾಗಿಲ್ಲ ಇನ್ನೊಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
I came to this the spot your lordship waited.
1 week time to.
Waited from 10:30
Court officer.
4:30, they could have informed. I could not have come from Hyderabad and I have informed to the other side council.
What time you came, sir?
10:30, your lordship. And 10:30 to 4:30, I have also called the respondents advocates, informed what you call about my staying there, and no response has been given by anybody.
Response to this letter, my lordship, again, is at 1 week time to. give some,
ಅಲ್ಲ ಮತ್ತೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಮಾಡ್ತಾರೆ ಮತ್ತೆ ಮಾಡಿ. ಬೇಡ 13-9 ಗೆ ಕೊಟ್ಬಿಟ್ರೆ. Can you appear on 13?
No, where is the statement saying that he has asked for time?
ಎಲ್ಲಿದೆ?
Morning he called me, this person. He sought 1 week time to produce some documents. He sought some documents in the notice money.
Lord, kindly fix another date. Lord, let him appear. Let the KDB officials also appear. Lord, let this survey be conducted. Otherwise, Lord, this Lord.
See, don't harass him, okay? He has to
Lord,
come all the way from
in
Hyderabad.
fact, Lord, he, Lord, filed, Lord, Lokayukta case against KDB officials. They, Lord, they are afraid to go, Lord, go before, Lord.
No, listen.
Let him, Lord, not influence and threaten, Lord, the officers, either, Lord, the state
Nobody is
officers.
threatening anybody. See, I'll tell you, he is a citizen. He is an absentee
Yes,
landlord.
filed cases.
Listen, he is an absentee landlord. He has purchased the property. He believes that his property is situated somewhere. You say his property is situated elsewhere. Let a survey be conducted.
Please, Lord.
Let it go on.
13-9.
Okay, when will you
Lord,
conduct?
Date 13-9.
As, Lord, let him
When
appear.
will you conduct the survey? Tell me that.
13-9. Fix the date, in that letter.
39 appear. Or appear other 39.
13-9-24. This week only.
On 13/9, they will conduct the survey, it seems.
I request your lordship may give some, because every week I am here. The problem is your lordship,
ನಾಳೆ
any
ಮಾಡಕ್ಕೆ ನಾಳೆ.
holiday, if my learned friend don't have an objection, Saturday or Sunday, your lordship, Because 39 I have parted matters in Amaravati court. Today also I have parted matter, but I made a request to the bench.
21st ಮಾಡ್ತೀರೇನ್ರಿ?
ಅಲ್ಲ ಅವ್ರು ಮತ್ತೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಸೇ ಮಿಲಾರ್ಡ್ ADLM.
First, I will request.
21st ಮಾಡ್ತೀರಾ? ಇಂಟಿಮೇಟ್ ಮಾಡಿ. 21st.
I leave to you.
Huh?
I leave to your lords.
My lordship, without notice, further notice, let him go and appear on 21st.
21st at 12 o'clock I will fix.
Please.
21st at 12 o'clock.
I leave to your lords.
Both the petitioner and the respondents submit that unfortunately, the survey could not be conducted on 4th September 2024 at 11 AM as directed by this court. And the respondents apologize for not doing so. Full stop. At the request of the parties, survey as directed by this court on 28/2024, 2024 is directed to be conducted on 21st 9/2024 at 12 PM. At the request of learned EGA, ಯಾವಾಗ ಬೇಕಪ್ಪ? Call on.
After 1 week.
ಆಮೇಲೆ ವೆಕೇಶನ್ ಶುರು ಆಗುತ್ತೆ.
ಅಲ್ಲ 24th 25th ಹಾಕೋಬಹುದು ಏನ್ ಸರ್?
ಅಲ್ಲ ಅಷ್ಟು ಬೇಗ ಇವ್ರ ಸರ್ವರ್ ರಿಪೋರ್ಟ್ ರೆಡಿ ಮಾಡೋದು.
ಅಲ್ಲ ರೀ. ಬಹಳ ದೊಡ್ಡದೇನು.
ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
1 week of the survey report. 21st ಆದ್ಮೇಲೆ 1 week.
I will call it on 30th. 30th, is it okay for you? To come over here?
No, anyhow, if your lordship directs, I will come, but the whole problem is my professional work.
Survey on 21st, sir. Survey on 21st.
Lordship, 21st I am here, your lordship.
Okay. 30th date could.
Much obliged. Much obliged.
Release from parted.
Lord, your lordship not heard the matter extensively.
Re, last day of the roster, re. ಸುಮ್ನೆ ನನಗೆ ತರಲ ತಾಪತ್ರಗಳು ಬೇಡ.
ನೋಡ್ಕೊಂಡು.
It's all right. Let's see. We'll continue on that day.
Very much obliged.
47, SM Babu.
Appear for the petitioner.
Na Purda Burdol. Government.
After tomorrow. Next time.
ರೇ ಅವ್ರಿಗೆ ಸುಮ್ನೆ ಪದೇ ಪದೇ ತರಿಸ್ಬೇಡಿ. ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಹೇಳಿ ಅವತ್ತು ಹಾಕೊಂತೀನಿ.
ಇನ್ನು 1 ವಾರ ಕೊಟ್ಟರು ನಂಗೆ ಚಿಂತೆ ಇಲ್ಲ, ಬಟ್ ಲೆಟ್ ಯು ಮೇಕ್ ಎಫರ್ಟ್ ಅಂಡ್ ಗೆಟ್ ಇಟ್.
He got the instruction.
ಆಯ್ತು, 1 ವಾರ ಬಿಟ್ಟೆ ಕೊಡಿ.
19th ಕೊಡಿ ಸರ್.
19th, at the request of AGA, call on 19th.
19. 48. Rakshita DJ.
I am appealing for the Lakshmi can dispose of this petition covered by division mail, and I am confined to it in a land mail as your lordship last occasion verified, and that is all that is the order still in the land. You knew of that division bench order, and time may be extended for another 3 months or 2 months, or whatever your lordship will leave it.
For what, sir?
For consider if I give the representation in terms of the observations of the division bench directions and do the needful, directing the authority to consider our representation after the pursuance of the division bench order.
What representation you have given?
Now, in fact, we given it is a
What do you want? You want alternative site?
ಹೌದು. Alternative ಮತ್ತೆ ಇದೆಲ್ಲ all these issues in fact certain portions has been developed. Certain portion land is they are all nursery, and also there is a.
You will be happy if alternative land is granted to you.
Land is exactly.
Division bench order kudi.
Division bench order reads like this, my lord.
That is writ appeal 1783 of 2014.
Exactly, exactly.
Huh?
ಹೌದು, writ appeal.
The petitioners
783 of 2000.
are landowners. Petitioner or petitioners? Petitioner ಅಂತ ಮಾಡಿ. Petitioner is was a landowner having a brick factory. Correct?
ಹೌದು.
The petitioner is said to be a landowner having a brick factory. In survey number 189/2 of Bhimanakuppe village.
Exactly.
Kengeri Hobli. Full stop. The said land has been acquired for the formation of Nada Prabhu Kempegoda layout. Full stop. Layout by the BDA. Full stop. Challenging the said acquisition, the present writ petition is filed. Full stop. Next para. However, in the course of arguments, the petitioner submits, he would be satisfied if his case were to be considered by the BDA as per the directions issued by this court in writ appeal number 1783 of 2014 and other connected matters in respect of land losers. Full stop. Next para. The counsel for BDA upon instruction submits that it has no objection to do the same. To consider the request of the petitioner. To consider the request of the petitioner. Full stop. Hence the following order. Respondent number 2 and 3 are directed
2 and 3. In terms of
to consider the case of the petitioner
as per the order of
as a land owner in brackets excluding the site owners. Correct, Tana?
ಹೌದು.
Brackets
As per the,
close.
as per the direction,
Uh,
Roman
as
I.
per the directions issued in
Roman 1 minor.
WA number 1783 of 2014. And pass and
In terms of
pass appropriate orders, cross appropriate orders within a period of
3 months.
3 months or 4 months, my lords, because they have to give representation, then we.
within a period of 3 months from the date of receipt of certified copy of this order.
Obliged.
Much.
There is another matter between me and Krishna. If they agree, they will dispose. I'm ready. It is the division bench covered.
Yeah, serial number ಎಷ್ಟು?
35 madam.
ಕೊಡಿ 35 ಪಾಸ್ ಓವರ್ ಆಗಿದಲ್ಲ. ಏನಿದು?
Division bench had
ಅದೇನೋ ಬೇರೆನಾ?
ಅದೇ same.
ಕೊಡಿ
35.
ಅದೇ ಆರ್ಡರ್ ಕೊಡಿ. What were you, a site owner or a land owner?
This is the ಅದೇ ಆರ್ಡರ್. ಇದರಲ್ಲಿ ಬ್ರಿಕ್ ಫ್ಯಾಕ್ಟರಿ ಇದೆ ಅಷ್ಟೇನೆ.
ಅಲ್ಲೂ ಬ್ರಿಕ್ ಫ್ಯಾಕ್ಟರಿ, ಇಲ್ಲೂ ಬ್ರಿಕ್ ಫ್ಯಾಕ್ಟರಿ.
In fact, same survey number, this is also in pursuance of it. Let them knew of this one order of the division bench. Now they issued an notice with the, we are called in question, man. That is.
ಆಯ್ತು, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬೋದಲ್ಲ?
We will refer to the committee, my lord, because ಅಷ್ಟೇ ಯಾಕಂದ್ರೆ this.
Writ appeal ಪ್ರಕಾರ ಡಿಸೈಡ್.
I don't want to make any distinction, but my lord, there are some observation in the writ appeal wherein the learned single judge order has been found fault with. I don't want, ಹೌದು. I don't want to mention that, but that is how what is.
ಈ writ appeal ಪ್ರಕಾರ ಡಿಸೈಡ್ ಮಾಡಿ.
ಹೌದು.
That is our division bench upholding the Nada Prabhu Kempegoda layout. Yes. Similarly placed people, you can find.
ಆಗಲೇ ಡಿಸ್ಕಷನ್ ಕೇಳಿಸ್ಕೊಳ್ಳಿಲ್ವಾ?
ಇಲ್ಲ, my lord, I was busy reading something.
ಈಗ ಅವ್ರ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಮಾಡಿದಿರಪ್ಪ.
ಹೌದು.
ಈಸ್ ನಾಟ್ ಎ ಸೈಟ್ ಓನರ್, ಈಸ್ ಅ ಲ್ಯಾಂಡ್ ಓನರ್.
Yes.
ರೈಟ್. ಬ್ರಿಕ್ ಫ್ಯಾಕ್ಟರಿ ಇದೆ. ಅಲ್ವಾ ಸರ್ ನಂಬರ್ 189/2
ಹೌದು, exactly.
ಅಲ್ಲೂ ಅದೇನಾ
ಹೌದು.
ಭೀಮನ್ ಕುಪ್ಪೆ ವಿಲೇಜ್
And also in keeping the division bench of this court.
ಇದರಲ್ಲಿ they have directed you to treat land losers in a particular manner.
ಹೌದು, exactly.
According to that you treat them, that's all. ಇದು same.
Along with the division bench order, you give a representative.
But he may not rely upon the judgment of the division bench which is filed now. That is in writ appeal 129, my lord, of 2021.
And passing an order as per writ appeal number 1783 of 2014.
Yes, yes, yes. Yes, my lord. Yes.
Okay.
Right.
Yes.
Yes.
Obliged. In terms of that order, it may be.
Number 49, A.K. Vasant, T.P. Vivekananda.
My lord, 2 weeks time may be granted, my lord. 2 weeks time may be granted, my lord. 2 weeks time may be granted, my lord.
14 minutes.
2014 matter. What is this? You are not conducting even one
Due to
case
some
before me. I don't know why.
Due to some inconvenience.
What inconvenience? Before this,
senior
you
not
got
able to-
inconvenience, is it?
Senior,
Alala.
some health issues, my lord.
Now listen, 1 or 2 cases I can understand. You are not willing to go on with even a single matter before this court. I don't know what's the problem.
Due to some health, he got some health issues, my lord.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಿಲ್ವೇನಪ್ಪ ಕೇಸು?
33 no ಇದೆ, my lord. Serial number 33 no.
ಅಲ್ಲಪ್ಪ ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಿಲ್ವೇನಪ್ಪ ಕೇಸು? ಕಂಡಕ್ಟ್ ಮಾಡ್ತೀಯಾರ ತಾನೆ?
No, he's not.
ಈ ಕೋರ್ಟಿಗೆ ಬಂದಾಗ ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತಾ?
No, my lord. He's not appearing.
The request of petitioner finally call next week. Otherwise I'll dismiss it next week.
My lord, serial number 33, same.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ, ವೆಯ್ಟ್ ಮಾಡಿ. ಕರೆದಾಗ ಹೇಳಿ. ಹಾ?
49 next week. Sir.
Next week.
49 next week. 50, Veregowda N.
ಅಶೋಕ್ ಆಲ್ರೆಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ರೆಡಿ ಇದ್ದು ಸರ್ಜರಿ ಆಗಿದೆ. ಫೈನಲ್ 18th ಹಾಕೊಳ್ಳಿ.
The request of petitioner call on 18th. Pass over ಕರೀರಿ.
Serial number, list 1, 5. List 1, serial number 5, pass over matters. M. Shiv Prakash.
Petitioner.
Murgesh Vijarati.
Yes.
Permitted to file the affidavit of.
He was asked to appear physically or through video conference.
Lord, I was, not failure to I'm filing an affidavit.
No, let him appear. Why was he asked to appear?
Lord, he was last time, the additional land acquisition officer appeared before your lordships. And, Lord, that is why the date was given to today. Lord, additional land acquisition officer had appeared before your lordships.
What do you mean?
But special land acquisition officer, Mr. Domber had appeared.
Okay. The advocate for, ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಟೈಮ್ ಬೇಕೋ?
Time ಬೇಕು.
ಟೈಮ್ ಬೇಕಾ? ರಿಜಿಸ್ಟರ್ ಫೈಲ್ ಮಾಡಿ. The advocate for respondent BDA submits that affidavit as directed by this court is ready. Full stop. Huh? Full stop and a copy is served on the petitioner, the counsel for petitioner. Full stop. Counsel for petitioner, raise time. Full stop. Respondent number 2 to 4 is directed to file the necessary affidavit in the registry. Full stop. In the light of the same, in the light of the same, presence of the secretary, PDA before the court is dispensed with.
Obliged.
ಯಾವಾಗ ಬೇಕು?
Date, Friday, madam. This week.
The request of petitioner call on Friday date.
13-9.
Please, please.
Pass over matter. Serial number 11. S.B. Mukkanappa. Serial number 11, S.B. Mukkanappa.
Dismiss for non-prosecution.
16.
Petitioner National Highways Authority, my lord, I've complied with the office objections. I've complied with serial number 1, number 2 and number 3 may be kindly overruled, my lord, because annexure U in that, if your honor would see the order that's mentioned at the top, in the Adesha portion on page 129. It refers to an order passed by this honorable court. It is a writ petition number 13482 of 2023 dated 27/11/2023, whereas the order is actually dated 12/2/2024. And the SLAO's order is without a number. So I have mentioned it correctly in the prayer, my lord. The office has misunderstood that this writ petition number is the number of the serial number and the date of the order. I may be permitted to press my interim prayer, my lord.
See, what is objection number 2?
My lord, it pertains to annexure U.
As per prior date of annexure, U does not tally.
Correct, my lord. So I have written.
Order date is 27/11/23.
My lord, that is the date of the writ petition order passed by this honorable court. That is not the SLAO's order date. On the last line of my lord would see Dinanka 12/2/2024. That is the date of the SLAO's order. And if your honor would see, there is no number for the SLAO's own order.
Yes. Office objections are kept open.
May I submit on the interim prayer, my lord?
One second, wait. What is this?
My lord?
National Highway Authority of India filing a writ petition on SLAO, National Highway Authority.
Yes, my lord. What has happened is, you're taking note of a conversion order that's been conversion sketch prepared in 2021, which is after the date of the final notification. The SLAO has enhanced the compensation by 6 crores, my lord. And the sum of 1.3 crores had already been paid by an additional.
Who takes notice for respondent number 1 now?
AGA would have to take notice, my lord.
Yes, AGA is directed to accept notice for respondent 1, 3 and 4, issue emergency notice to respondent number 2. What is the admitted compensation?
My lord, the admitted compensation which has been paid is 1.3 crores, my lord.
It is already paid?
It's already been paid. So thereafter, what happens is they approach the arbitrator. The arbitrator states that you please verify this conversion sketch.
There shall be a stay on disbursement of compensation pursuant to the order dated
12/2/2024.
pursuant to the order dated 12/2/2024.
At annexure U and the endorsement at annexure R.
Passed by respondent number 1 void annexure U to the writ petition. And also the endorsement.
At annexure R, my lord.
And also as per the endorsement dated so and so, void annexure R to the writ petition issued by respondent number 1. Full stop. The interim order shall be enforced till next date of hearing.
Petitioner, my lord. Office objections are complied, my lord. Matter pertains to general award.
General award, consent award.
ಎರಡು award ಇದೆ sir. There are 2 awards.
ಎರಡು award ಅಂತ ಎರಡು. ಗೊತ್ತಾಗುತ್ತಲ್ಲ?
33 pass over matters. 33 KK Vasant.
The request of petitioner call next week.
Lord, see this matter, my lords, in the morning. My name may be deleted, shown, my lords. Murgesh Charati was appeared, my lords, in the morning by oversight.
Yeah, there are 2, 3 ga.
Are you in council, Sachin BS, my lords? My lords, what happened is in the morning, my lords, I was held up in some other court, my lords. ಸಚಿನ್ ಅವ್ರೆ.
ಆಯ್ತು, ಇದು 33
ಹೌದು. Because my lords 32 was urgent in the morning.
ಆಯ್ತು, ಅದೇನ್ ಬೇಡ. ಓಕೆ, ಅವ್ರು ಹೇಳಿದ್ರು ನಾವ್ ಹೇಳಿದ್ವಿ, ನನಗಂತ.
ಇಲ್ಲ, what happened is 32 was urgent in the morning itself. Madam has appeared.
His colleague appeared and she made a
Yes,
mention
yes.
of it.
By oversight, it was submitted. My lord. Was sorry for that.
Yes.
My lord, serial number 11, my lord. Serial number 11, my lord.
ಹಾ,
Beg apology, my lord. I have sir. Total number 27.
ಆಯ್ತು, ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಬೇಡ.
ಮಾಡ್ತೀನಿ sir.
ಅಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಬೇಡ, ತೆಗೀರಿ. ವಾಟ್ ಇಸ್ ದಿಸ್ IAS?
ಅದು ಎಲ್ಲಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಸುಮ್ಮನೆ petition
Allow
number 2
ಮಾಡ್ಬೋದೇನ್ರಿ?
ಡೆಡ್ ಆಗಿದ್ದಾರೆ.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ ಕಾಪಿ?
ಕೊಟ್ಟಿಲ್ಲ. ಸರ್,
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ, ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ಮಾಡ್ತೀವಿ. ಈಗಲೇ ನೋಡಿ.
petition number 2 ಡೆಡ್ ಆಗಿದ್ದಾರೆ. ಅವ್ರನ್ನ ಎಲ್ಲಾರ್ಸ್ ತಂದಿದೀವಿ ಸುಮ್ಮನೆ ಅಷ್ಟೇ.
Orders on IA 1 of 2023. The aforementioned IA is filed to bring the legal representatives of deceased petitioner number 2 on record. Full stop. It is submitted that petitioner number 2 died on.
my lord. Lord, 6/7/2022, 6/7/2022, my lord.
6/7/2022. Full stop. Except in the cause shown, the aforementioned IA is allowed. The proposed legal representatives are permitted to come on record. The advocate, full stop, the advocate for the petitioner is directed to amend the cause title and file amended petition within a period of 2 weeks from today.
Much. Lord, intermodal may be extended.
Intermodal ಇದ್ರೆ ನೋಡ್ಬಿಟ್ಟು extend ಮಾಡಿ.
Much. Serial number 15. ಅದನ್ನು ಪ್ರಾಸೆಸ್ಗೆ ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು intermodal was not extended. Last date was on 22/8/2024. On 23 itself, my lords have paid the process money. ಹಾಗಾಗಿ ಅದರ status ಕೋ ಒಂದು.
Objection comply ಮಾಡಿ.
ಅಲ್ಲ, objection, my lords, regarding prayer number 2. ಅದರಲ್ಲಿ ನಾವು ಕ್ಯಾನ್ಸಲೇಷನ್ಗೆ ಕೇಳ್ತಾ ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ. We are seeking only mandamus to the BDA.
ನೋಡಿ, ಪ್ರೋಸೆಸ್ ಯಾವಾಗ ಕಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. ಪ್ರೋಸೆಸ್ ಯಾವಾಗ ಕಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
23, my lords. Madam. ಅದರಲ್ಲಿ because ಏನಾಗಿದೆ ಅಂದ್ರೆ in 1985 ನನಗೆ
ನೋಡ್ರಿ, ಅದು ವೆರಿಫೈ ಮಾಡ್ರಿ.
ಮೇಡಮ್
Status 17449 of 24.
23/7/24.
ಆಯ್ತು, 1 week time ಅದರಲ್ಲಿ 14 ಅಲ್ಲ 15 ಅಲ್ಲ
15.
1 week time is granted to comply the office objections. Intermodal if any is granted earlier ಅಂತ ಮಾಡಿ. Is extended till next date of hearing.
My lords, only one submission. The prayer, the objection is with respect to prayer number 2. ಅದನ್ನ kept open ಮಾಡ್ತಾವ್ notice issue ಮಾಡಿದ್ರಿ. So that is regarding seeking mandamus to BDA to cancel the sale deeds. That was kept open and notice was issued, my lords.
Office objection ಏನಿದೆ ನೋಡಿ. ಆಯ್ತು, 2:30 ಹೇಳಿ. Come at 2:30.
ಆಯ್ತು.
ಫೈಲ್ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ಪಾಸ್ ಪ್ರಾಪರ್ಲಿ.
ಆಯ್ತು. Yes.
Digital.
my last kind permission, serial number 14. Serial number 14, my lord. I represent petitioners, my lord. There is a ejectment suit, my lord. I have given a proposal for settlement. Now we are paying 1,65,000 rent, my lord. I have told them to enhance for another 1 lakh. My lord.
I'll call.
Rich, please.
Pass over matter, serial number 15. Wait, sir. Serial number 15, wait, madam, call ಮಾಡ್ತೀವಿ. ಹಿಂದೆ.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ ಕೊಡಿ. So observations comply ಆಗಿದೆಯಾ? Okay, at the request of the learned counsel for the petitioner, 1 week time is granted to comply with the observations. Full stop. Interim order granted earlier is extended till next date of hearing.
Obliging. List one. Second list. Second list. Second list.
My lord, serial number 19.
Serial number 1. Serial number 1, R. Gopal.
Hearing for a petitioner, my lord.
R. Gopal.
For petitioner.
Here, Patil.
My lord, service of notice may be held sufficient, my lord, in the respect of lots of. They refused, my lord.
How many times it has gone on?
We have given PF for 4 times, my lord. Refused ಅಂತ ಬಂದು ಶರ.
Oh, yes, 4 times, so yes. 4 respondent 2A 4 times. 2A CC.
As respondents 2A to C and respondent number 4C have refused to receive the court summons. Service against them is held sufficient. Yes, what is this matter?
Lord, we have filed IA for bringing LRs of R2 and R4, my lord. ES may be allowed, my lord, for bringing LRs.
allow ಆಗಿಲ್ವೋ? R2 and R4.
Please, my
2-3 ಜನ ನೋಡಿ. IA ನೋಡಿ. IA for bringing a loss on record.
Only 3 members.
ಯಾವ IA ನೋಡಿ ಅದು? Order sheet check ಮಾಡಿ first. ಇದ್ಯಾಕಿದು ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ? ತೋರಿಸ್ಬೇಕಲ್ಲ. How many IAs you have filed to bring legal representatives of deceased R2 on record?
We have filed 3 applications.
ಯಾವ್ದು?
3 of 22, 2 of 22, 3 of 21. 1 of 21, 2 of 21, 3 of.
ಸರಿಯಾಗಿ ನೋಡಿ ಹೇಳ್ರಿ, ಅವನು ತಪ್ಪಾಗ್ಬಾರ್ದು.
1 of 21. 1 of 21, condemnation of delay. 2 of 21, 21 objection. 3 of 21, bringing the loss of A, B, C.
That is 4, R4.
2, sir.
2, okay. Orders on IA so and so ಬರ್ಕೊಂಡ್ರಲ್ಲ? It is submitted that respondent number 2 died on Death certificate.
14/1/2020, my lord.
14/1/2020. Full stop. The aforementioned IAs are filed to bring his legal representatives on record. Full stop. Legal representatives on record by setting aside the abatement and condoning the delay in filing the application. Full stop. Except in the cause shown, the aforementioned IAs are allowed. Abatement is set aside, delay is condoned, and the LR application is allowed. The proposed legal representatives are permitted to be implemented as respondents to A to C. Next, the
Respect to R4, my lord.
R4 more application,
Please, my lord.
4 of 21, 5 of 21, 6 of 21.
ಇದು ಸೇಮ್ ಆಟ. ಯಾವ್ದು ಸತ್ತೋಗಿದ್ದ?
28/5/19, my lord.
Death date 28/5/2019.
Please.
Yes, advocate for the petitioner is directed to amend the cause title and file amended cause title within a period of 2 weeks from today.
Please.
ಯಾವುದು?
7 of 21,
ಯಾವ್ದಕ್ಕಿದೆ ಅದು?
8 of 21.
petitioner ಸತ್ತೋಗಾರ ಆರ್ಡರ್ಸ್ ಆಗಿಲ್ವಾ ಅದ್ರ ಮೇಲೆ? ಏನ್ರಿ ಇದು ಪಿಟಿಷನರ್ ಸತ್ತೋಗಿದಾರ?
ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆ.
ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತಲ್ಲ, ಚೆಕ್ ಮಾಡಿ. ಅದಕ್ಕೆ ಆರ್ಡರ್ ಚೆಕ್ ಮಾಡಿ. You're sure the IA is allowed?
7, 8, 9, hello.
We have amended the cause title.
Yes.
Two.
My lord, serial number 2, my lords, I appear for the petitioner.
Yes.
The a week's time may be granted, my lords, I'll do the needful.
Yes, 1 week to do the needful.
Grateful, my lords.
3, number 3, TV Chandrasekhar.
For the petitioner, I pray 1 week time.
With the request of petitioner, 1 week time is granted.
Sir,
Take
sir, 3.
dismissed, The petition is filed challenging an order passed in execution case number 635 of 1997. Full stop. The online case status reveals that the execution petition itself has been disposed on 31/3/2018. Full stop. For the said reason, writ petition is dismissed as having become infectious. Yes. No, the other. Right. Oh, correct.
4, Mohan Bhatt.
ಇದು TCR ಬಂದಿದ್ಯಾ 3 ನಲ್ಲಿ?
Hearing for the petitioner, my lord. My lords, we have done the needful.
PF cover acknowledgement.
ತಪ್ಪಪ್ಪ ಇದೆ. TCR ಏನ್ ಬಂದಿಲ್ಲ ಅಲ್ಲ?
Yes, sir.
My lords, we have submitted the same before the counter.
Once again, counsel, it was with regard to serial number 3. Yes.
Number 4, Mohan Bhatt.
Have you rectified the office objections?
My lords, we have submitted the cover
What
acknowledgement.
about office objections? Has it been complied?
My lords, we have done the needful.
Needful ಆಗಿದೆಯೇನ್ರಿ?
Yes, sir.
Advocate for the petitioner submits that needful has been done and process has been paid. Office to verify and proceed.
My lords, interim order may be extended.
Interim order, if any, is extended till legislative hearing. ನೋಡ್ಬಿಟ್ರಿ. ಇದೆಯಾ? Interim order, if any, is extended till legislative.
Grateful, my lords.
5, Vinod. Yes. Number 5, Vinod, yes.
One week to do the needful finally.
6, Suraj Sampath.
appear for petitions, my lord. My lord, the office objections had already been complied, my lord. And regarding the acknowledgement, I filed it along with the memo, my lord.
Council submits that needful has been done, huh? Office to verify and proceed. The
To the
aforementioned
petitioner, your lordship. I pray for 2 weeks to do the needful and,
infractions are note ಕೊಂಡು ಬರ್ಬೇಕು. What is this?
sorry, I apologize.
The aforementioned writ petition is filed against an order passed on an interlocutory application in OS 135 of 2012, which was pending on the file of so and so. Yeah, full stop. The online case status reveals that the original suit itself has been disposed on 19/6/2024. Yeah, full stop. For the said reason, the writ petition is hereby dismissed as having become infructuous.
Apologize.
8. Yes, Kumar.
Petitioners, week time may be granted, my lord.
1 week to do the needful.
9. Subhash Salgar.
1 week to do the needful finally.
10. GS Bhatt. Number 10, GS Bhatt.
Counsel for the petitioners, my lord. My lord, there's a memo as well as an IA pending. Memo reporting debt of respondent number 1. And IA for substitute service of summons.
Substitute service
For respondent number 2. Respondent number 1 is passed away, my lord, on 18/8 of 23.
You have to file the application of council.
No, I have reported debt, my lord.
Correct. It will
She's
be
already
updated
on
if you
record.
don't file an application to bring LRs on record.
LR is respondent number 2, my lord. Respondent number 1's LR is respondent number 2. The only,
Yes.
yes,
Okay.
ma'am.
The advocate for the petitioner submits that respondent number 1 died on
18/8, my lord.
18/8.
No, 1 second.
8/2023.
8/8/2023.
8/8/2023. And that respondent number 2 is the sole legal heir of respondent number 1. And there is no need to make an application bringing his LRs on record. His submission is placed on record. And
There is an IA.
respondent number 2 is treated as the legal representative of deceased respondent number 1. Full stop. ಇದು IA1 ಏನಾಗಿದೆಯಪ್ಪ?
My lord, IA number 1 is for substitute service of summons. 3 times we have sent it through RP.
ಏನಾಗಿದೆ? ಏನಂತ ಬಂದಿದೆ? ಅಲ್ಲಪ್ಪ, ಶರ ಏನಂತ ಬಂದಿದೆ? ಅಡ್ರೆಸ್ ಸರಿ ಇದೆಯಾ?
Inquiry. No such person. On inquiry, no such person. R2.
ಇದು OSL ನೋಡಿ. What are you in original suit?
We are the plaintiff, my lord.
Plaintiff.
Yes.
Have they been served in the original suit? OS address ತೋರ್ಸ್ರಿ.
The original suit is being continued, my lord. It is at the stage of evidence as of now.
Number 18,
You don't think you serve on the council for respondent number 2? ಇಬ್ರನ್ನ respondents ಆ?
ಹೌದು, my lord. Ibra.
ಇಲ್ಲಿ ಎಷ್ಟೊಂದು ಜನ ಇದಾರ? ಇದರಲ್ಲಿ ಎಷ್ಟು ಜನ ಇದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್? 4 ಜನ ಇದಾರಲ್ಲ, 6 ಜನ ಇದಾರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
I'll get back to them.
What has happened to others?
My lord,
R5 served, sir. R6 served. R1 and R2. ಬೇರೆಲ್ಲ ಸರ್ವ್ ಆಗಿದೆ ಸರ್. R3 HK ರವಿ. Appearance. 3, 4, 5, 6. 3 HK Ravi appearances. 4, 5, 6 served. 1 dead, 2.
I have heard the advocate for respondents in the trial court.
Sorry, my lord.
12.
Have you served the advocate for respondents before the trial court?
No, my lord.
Huh? Petitioner is directed to ಮಾಡಿದಾರ ತಿಳ್ಕೊಂಡು ಹೇಳ್ರಿ. ಏನಂತ ಈಗ ಏನ್ ರಿಸೀವ್ಡ್ ಅಂತ
My lord,
sheet ಅಲ್ಲಿ ನೋಡಿ were they permitted to serve the counsel for respondents? Petitioner is permitted to serve the counsel for respondent appearing in the trial court. Call after 2 weeks.
Number 11.
This IA will be alive
yes, my lord.
in spite of you taking out service to the advocates. If they don't appear, we'll order paper publication.
Okay, my lord. But meanwhile, time may be granted for compliance, my lord.
Even complaints.
The addition is not been added in the.
You file an application, proper application.
All right, grateful.
11. Abhinay Whitey.
So respondent number 1 is unserved, my lord. 3 days time to file necessary application to serve notice on him by the way of substituted service.
ತಗೊಳ್ಳಿ ನೀವು ಎಲ್ಲಿ ನೀವು
ತಗೊಳ್ಬೇಕು.
The request of petitioner call next week.
Yes, ma'am.
12. Chandranath Riga.
Serial number 3 close ಮಾಡಿದ್ರಂತೆ. Serial number 3.
Influxes
ಇಲ್ಲ. That was closed because there is a stay by the Sovereign Court. The Lordship kindly say on 18 to 2019 or similar, that was again recalled. It was only closed because the stay is pending before the Sovereign Court. ಅಲ್ಲ ಮುಂಚೆ ಮಾಡಿ ಮತ್ತೆ ರೀಕಾಲ್ ಆಯ್ತು ಅದೇ ತರ 18 to 2019 ಅಲ್ಲಿ.
ಹೌದಾ? ಓಕೆ. ಆರ್ಡರ್ 3 ನಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಆರ್ಡರ್.
The calculations TDS na minus ಮಾಡಿದ್ರೆ that's the only.
Okay. 1 week to do the needful. 1 week time is granted to the petitioner to take steps to have unserved respondents, sir. She has written, we do not see this. She has written it.
25 questions.
It's all right. Yes.
12.
Pray for weeks time to.
Yes, 1 week to do the needful.
13. Rajgopal Naidu. Number 13. The last time.
None appears to the petitioner. Even on the last date of occasion, none appeared for the petitioner. The writ petition is of the year 2018. It appears petitioner is not interested in prosecuting the writ petition. Writ petition dismissed for non-prosecution.
14. M.N. Madhusudan. Number 14.
Right.
R.B. Sadashiva.
My lord, in this matter, my lord, suit for ejectment, my lord. I have requested my senior friend, my lord, the matter is ejectment, my lord. We are paying a rent of rupees 1,65,000, my lord. We are ready to pay enhance another 1,30,000. And I requested senior, if he agrees, we'll settle the matter. Todadappa Choudhury, and my client is a prompt payer in rent, my lord. 1.5 crore due was also there before COVID. We paid entire no arrears of rent, my lord. And I requested senior counsel if they agree, even if I vacate also, my lord, they are going to give some other person. I requested my client also, I advised him to pay enhanced rent. If they agreed for enhanced
Then
proposal.
scope for negotiation, sir. Any scope for negotiations? So when do you want? Date ಬೇಕಾ ಅದು ಸುಮ್ಮನೆ 2 weeks ಅಂತ ಅರ್ಜನ್ ಆಗಲ್ಲ.
One date ಇರ್ಲಿ sir, ಇಲ್ಲ ಅಂದ್ರೆ.
Date ಇರಲ್ಲ.
ಅದು ಮ್ಯಾಟರ್ನು ಬರೋದಿಲ್ಲ, old matter, we'll finish up.
At the request of parties call on date ತಗೊಳ್ಳಿ sir, date of your choice. When do you want?
10 days. Gijesh.
2 weeks ಬಿಟ್ಟು ಒಂದು date ಕೊಡಿ.
23, 23.
Please, man, much over.
Number 15, Vivek Ulla.
The petitioners, my lord. My lord, I filed an IA for bringing the LRs on record. The sole respondent is passed away. She survived by one son. The son has been served, my lord. The application may kindly be allowed.
Only one respondent.
Only one respondent.
Recall ಮಾಡ್ಬೇಕಾ? Petition against R1 is dismissed ಅಂತ ಇದೆ.
No, my lord, that was on a previous occasion when process was not paid, my lord. Process was paid on the same date, but that was not brought to the notice of the court.
No, 20, but order has to be recalled, no? 24/1/24.
No, my lord, I think it has been recalled on the previous date of hearing, my lord.
Good.
It was recalled on 29/2/2024, my lord.
Yes, orders on IA 104 and 22. It is submitted that respondent died on.
My lord, the date we are not aware of, my lord.
The respondent, the respondent died and the aforementioned IA is filed to bring the legal proposed legal the legal representatives of the deceased respondent on record. Full stop. Accepting the caution, the same is allowed. Petitioner is the proposed legal representatives is permitted to be brought on record as respondent number 1A. Huh? ಮತ್ತೆ ಸೆಂಟೆನ್ಸ್ ಒಂದು ಮಿಸ್ ಆಯ್ತು ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಬಿಡಿ. The proposed legal representative is served and unrepresented. ಆಮೇಲೆ continue. Advocate for the petitioner is petitioner is directed to amend the cause title and file amended petition within a period of 1 week from today. Yes, what is the matter?
My lord, it's a suit for eviction and arrears on rent, my lord. I filed 4 IAs, my lord. One was in regards to payment of rent at 60 at a certain
Entry
amount
model,
every month, my lord. There were 4 IAs, of which 2 of them were dismissed and 2 of them were.
Entry model ಇದೆಯಾ?
ಇಲ್ಲ sir. My lords, can I kindly request my lords to have it next week? I'll argue the matter on the merits.
Let me see.
Please.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಈಗ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Please, my lord. Evidence ಆಗಿದೆ ಸ್ವಾಮಿ. Argument stage ಅಲ್ಲಿ. There is another IA number 15 that has been filed. It's at
This writ is only against IA number 1.
Please, ma'am. Only against IA number 1. That is with regards to the monthly rentals that I've sought during the pendency of the suit, my lord. fact, my lords, I've produced various email communications between the plaintiff and the defendant, wherein they seek to negotiate the terms of the rent as well as,
$10,000, sir.
please, my lord,
Huh?
please, my,
$10,000 per month.
please. That is the amount that was agreed to, my lord.
Get to the property.
My lord.
₹8 lakhs ಚಿಲ್ಲರೆ ಆಯ್ತಲ್ರಿ?
My lord, that was the amount that was agreed to between the parties. And we also produced proof of payment of such amounts on various occasions, my lord. It's an independent house, my lord, in Langford Gardens, so I'm assuming that's a very
No.
high rental locality. My only grievance is, my lord, even as on date, they are in possession of the property. But I don't seem to profit from owning it and I don't get any rent out of it. I've not been able to rent it out to anyone else also.
Nimsha, come to page number 66. Internal page number 18 of the order.
Please, my lord.
Last two lines odi. Jora odi. Last two lines of the.
For the documents produced.
Without holding inquiry. Internal page number 18.
During inquiry, the court cannot come to the conclusion regarding the monthly rent fixed by the parties. Such being the case, it is not proper to
Yes.
direct the defendant.
Okay, I'll do one thing. I'll direct, I do not see any reason why it should be disagreed because lease agreement has not been produced.
My lord, they were.
Listen, it's a disputed question of fact, which can be resolved after evidence is recorded. Okay, keeping the thing open, I'll direct the trial court to hear the matter as expeditiously as possible and dispose of the matter.
Please, my lord.
Yes, Bunny.
But my lords, can I request for it to be had on Monday?
ಏನಾಗಲ್ಲಪ್ಪ ಅಷ್ಟೇ ಆಗೋದು. You have made a good work, don't worry about it. Agreed by the order passed on IA number 1. Tell your senior, ask him to come here, I'll tell that you have done a wonderful work. Don't worry about it.
If a time period may kindly be fixed for the disposal.
Time period ನಾನು ಫಿಕ್ಸ್ ಮಾಡಬಾರ್ದಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆದೇಶ ಇದೆ. Yes, agreed by the order passed on IA 1 in OS number 8624 of 2016 by 39th additional city civil judge at Bangalore. The present writ petition is filed. Full stop. Client ಹಾಕಿದ್ದೀರಾ?
Please, my lord. It is at page number 15, son. Annexure A.
The petitioner is the plaintiff. Plaintiff ತಾನೇ ನೀವು?
Please, my
In the original suit. Full stop. He filed the same for ejectment and recovery of arrears of rent. He know, she know. She filed the same. She filed the same for ejectment and arrears of rent. Ejectment of defendant. Ejectment of defendant from the suit schedule property and recovery of arrears of rent. Full stop. She also filed IA number 1 of IA number 1. In the original suit. With a prayer to direct the defendant to direct the respondent herein to pay the petitioner an amount of an amount of $10,000 per month. Correct, Andre? Huh? As rent during the pendency of the suit. Correct, Andre?
Correct.
$10,000 rupees alla. Next para. The respondent in her return statement has denied the landlord-tenant relationship between the petitioner and respondent, and also has denied the right of the petitioner to recover rents from the respondent. Full stop. The next para. The petitioner has not produced any lease deed to prove the landlord tenant relationship, but has relied upon exchange of emails and letters, exchange of emails and letters in this regard. Full stop. Next para. The trial court, based on the evidence adduced, the documents produced, came to the conclusion that to prove landlord-tenant relationship between petitioner and respondent, inquiry needs to be held. Trial needs to be conducted. Trial needs to be conducted. And only after reducing of oral evidence and marking of relevant documents, the issue can be resolved. Full stop. Based on the said, based on the said, but hence, IA1 filed by IA number 1 filed by the petitioner in the original suit has been rejected. Full stop. Next para. I do not see any error in the order passed by the trial court. Full stop. Admittedly, there is no lease deed existing between the petitioner and respondent. Correct, thane? Helbodalla. Admittedly, there is no lease deed existing between the petitioner and respondent. Full stop. The case of the respondent is that there were negotiations regarding purchase of the property, resulting in petitioner permitting the respondent to reside in the property. Full stop. No document is produced to establish no admitted document has been produced to establish that there was a landlord-tenant relationship and the rentals were fixed at $10,000 per month. At $10,000 per month. Full stop. Under the circumstances, the petitioner is required to establish her case by adducing oral and documentary evidence, and the court can come to a conclusion as to the existence of landlord-tenant relationship between petitioner and respondent, and also the amount of rent payable by respondent to petitioner, if any, only on appreciation of evidence, and not prior to it. Full stop. Next para. For the aforementioned reason, I do not see any error in the order passed by the trial court. Full stop. For the said reason, the writ petition is, for the said reason, but hence the writ petition is hereby dismissed. Full stop. However, taking note of the fact that the suit is of the year 2016, the trial court is hereby directed to take up the case on priority and dispose of the same as expeditiously as possible. And the parties are directed to cooperate with the trial court for quick disposal of the original suit.
My lords, can I also request for my lords to record that there was no opinion on the merits of the case? Can I record them?
It is needless to state, full stop, it is needless to state, any observations made herein above shall not influence the trial court. It is needless to state, the trial court shall not be. It is needless to state that the trial court shall not be influenced by any of the observations made herein above, and shall decide the original suit based on the materials, based on the pleadings and the evidence let in by the parties.
Appearing for petitioner, my lords.
Recontain.
Ready, my lords. My lords, the present suit is for injunction, lords, filed by the respondents here. And the petitioners are the defendants before the trial court, my lords. Petitioner, the respondent has filed IA under Order 39, Rule and 1 and 2. The trial court has allowed it, my lords, against which I file miscellaneous appeal. The appeal is dismissed, my lords, convergent filings. My lords, the respondent plaintiff, my lords, is claiming right under a sale deed, which is executed by my brother's wife, my lords. My lords, what is important?
What is the interim order passed?
My lords, stay of operation of order, my lords. Stay of operation of order.
No.
Injunction, my lords. Injunction restraining not to interfere, my lords. Possession. That's what is important.
Entry mode release.
That's at page annexure D, my lords. D and E. D is the order of trial court, my lords. Page 64 minutes. Trial court. Operation portion is at 75 months.
Vacant land, ah?
Vacant trees, ಮತ್ತೆ
Construction ಏನಿಲ್ಲ.
constructions ಇಲ್ಲ. My lords, what is important to note, my lords, is that before filing of the injunction suit, my lords, I have filed a suit for partition, my lords, because the respondent is claiming a title under my brother's wife, my lords. With respect to very same subject matter, I filed a suit for partition in the year 2015, my lords. Suppressing the partition suit, my lord, in the year 2017, the respondent goes and files the present suit for injunction, my lords. On that,
When did he purchase the property?
3/1/2015, my lords.
3/1,
2015.
2015 purchase.
Yes, my lords.
Huh?
Yes, my
You
lords.
filed partition suit when?
10/4/2015. My lords, suppressing the partition suit, my lords. In the year 2017, he files a suit for injunction, my lords. Even in the plaint, my lord, which is produced before your lordships.
Partition suitor, have you made him a party to the?
He is a party, has filed a written statement, my lord. In the written statement, my lord.
In the partition suit, do you have any interim order?
No, my lords, there's no interim order, my lords.
Then?
My lords, in the partition suit, my lords, he has filed a written statement claiming he has not raised any strong defense, my lord. On the other hand, my lords, what he has raised is, if at all a court comes into a conclusion that it is a joint family property, he won't claim any equity. This was the stand taken by him in the partition suit. Suppressing all these, my lords, he files a suit for injunction.
Okay, let him enjoy possession, let him not change the nature of the property or put up construction.
My lords, suppression of my material fact itself is a good ground for denying.
Council, we are seeing 101 cases, thousands or lakhs of cases in this country where one family member sells the property. The other family member goes and files a suit.
My lords, the conduct of the.
Ray, it's your conduct, Ray. It's your conduct. You can't settle it between your family.
My lords, I filed immediately after the sale deed, my lords. I filed a suit, my lords.
You people indulge in extortion.
My lords, immediately after sale deed, my lord, I filed a suit, my lord. That may be kindly looked into, my lord. In the year 2015, I filed a suit for partition, my lords. In the year 2017.
Show me your right. What's your right over the property?
My lord, the property is granted to my father under land by the land tribunal, my lords. Tenanted property, it was re-granted, my lords. My father dies interstate, my lords. After interstate, my lords, the revenue records was continuing in the name of my brother.
I heard you both. I'll modify the order. I'll modify the order. I'll say that they will not interfere with your peaceful possession. At the same time, you will not change the nature of the property, nor will you put up any construction on the property.
My lords, there is burial ground, my lords.
Okay, it's all right.
My lords, there is burial ground, my lords. Family members ಎಲ್ಲ ನಾವು ಸಮಾಧಿ ಮಾಡಿದೀವಲ್ಲ ಅದಕ್ಕೆ ನಮಗೊಂದು ಸ್ವಲ್ಪ.
Anything else?
My lords?
Anything else?
My lords, I have a similar citation, my lords, on the same set of facts and circumstances.
What is your sale deed? Tata was standing in whose name at the time of sale? Annexure?
My lord, that is just a pauti kata, my lords.
Who Muni Narayanappa?
He's my brother, my
Is your brother.
He was the elder member of the family, my lords. I am the daughter, my lords. My lord, that is Pautikata, my lord. In the 59/2009, my father dies, my lord. In the year 2010, the kata is mutated in the name of Muninarayana. My lord, with your lord's kind permission, my lord, may I place one citation, my lord, on the same set of facts and circumstances, my lord, of coordinate bench, my lord. With
If you had an interim order in your favor in the partition suit, okay, I'd have granted user relief. Okay. Anyway, this order will be safeguarding your interest also. Putting a condition, he will not alienate the property or create any third-party rights over the property concerned. Number one. Number two, he will not change the nature of the property, nor will he put up any construction on the property. Okay. To this extent, see, admittedly, what happens, he is in possession of the property by virtue of the sale deed. You are a daughter, your claim is only for a joint possession. You are not in actual physical possession, it's constructive possession.
Joint possession.
Correct?
Correct.
So, as long as third-party rights are not created, as long as nature of the property is not changed, tomorrow if you are able to establish you have a right over the property, you will automatically get a right over it. Okay. So with that observation, I'm going to close it. So to that extent, I'm going to modify the order.
That's
Fair
one
and
submission,
equitable
my lord,
order.
because there is burial ground, my lord. That's the reason we are fighting the matter till the High Court, my lord. That's the only reason, my lord. Samadhigalira, adike.
Hence, I say, I'll also say that what do you say for Samadhi?
Graveyard.
Grave.
Tombstones.
It will not be disturbed by them. That observation also will be. Okay. Yes, Bunny. You cultivate the land. You cultivate the land. But you will not disturb the, what do you say, the graves, if any, present over there. Yes, Bunny, agreed by the order passed on. Tell us the impugned order.
My lords, Annexure F, my lords. 15/3/2018 in MA 9/17.
Agreed by the order dated 15/3/2018. Passed on the interlocutory application filed under Order 39 Rule 1 and 2 CPC in OS number 10/2017. Correct, Andre?
MA, my lords. MA 9/2000, sir.
Date ಬಂದು 24/4/2017. Correct?
24/4/2000.
24/4/2017. And also the order dated 15/3/2018. Passed on the miscellaneous, passed in the miscellaneous appeal number 9/2017 by so and so court. Adunu by so and so court ಅಂತ ಸೇರಿಸ್ಕೊಳ್ಳಿ ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ. The present petition is filed by
Defendants.
the defendants in the original suit. Full stop. Next para. OS number 10/2017 is filed by next to Erika Markle. For sake of convenience, the parties are referred to as per their status before the trial court. Full stop. Next para. OS number 10/2017 is filed by the plaintiff. Plaintiff is filed by the plaintiff. The plain prayer. Yes, filed by the plaintiff, for a relief of permanent injunction restraining the defendants from interfering with the plaintiff's apostrophe S peaceful possession and enjoyment of the suit schedule property. Full stop. Along with the said original suit, the plaintiffs also preferred an application and order 39 Rule 192 CPC with a prayer to restrain the defendants from interfering with the peaceful possession of the plaintiff over the suit schedule property. Overall, of the suit schedule property. Of the suit schedule property. Full stop. The trial court. The trial court. The plaintiff has filed the original suit on the strength of a sale deed dated 3/1/2015, through which he purchased the suit schedule property from the wife and children of one Muni Narayanappa, who happened to be the brother of the
Petitioner.
husband of defendant number 1 and father of defendant number 2.
Muni Narayanappa is the brother of defendant number 1.
So how is what about defendant number 2?
Defendant number 2 is my son, my lord.
Father of defendant number 2, what is that? Who happened to be brother of
Defendant number 1.
defendant number 1. Full stop. In other words, late husband of defendant number 1 and late husband of defendant number 1 was the brother of late Muni Narayanappa. Muni
Okay, sir.
Narayan.
That is my father's property. Petition.
In other words, petitioner defendant number 1. In other words, defendant number 1
Is the sister of
is the sister of
Muni
late
Narayan.
Muni Narayana. Late Muni Narayana. Full stop. The as next para as the plaintiffs had purchased the property, suit schedule property by way of a valid sale deed, and the revenue documents stood in the name of the plaintiff, the trial court allowed the application filed under order 39 Rule 1 and 2 and granted an order of temporary injunction restraining the defendants from interfering in the property. In the property. Full stop. The order of the trial court was challenged in MA number so and so by the defendants / petitioners herein, which also came to be dismissed. Full stop. Agreed by the same, the present writ petition is filed. Full stop. Next para. The case of the defendants is that the suit schedule property belonged to father of defendant number 1 and late Muni Narayanappa, and that he died intestate. Full stop. However, as late Muni Narayanappa was the elder son, and petitioner and the defendant number 1 happened to be the daughter, the sister of Muni Narayanappa, happened to be a lady in Tamil, happened to be a lady, comma, the revenue documents pertaining to the suit schedule property stood transferred in the name of late Muni Narayanappa. Full stop. Subsequently, the said Muni Narayanappa also died. Full stop. Immediately thereafter, his wife and children, comma, behind the back of the defendants, comma, immediately got the revenue documents transferred in their name and sold the suit schedule property in favor of the plaintiff on
3/1/2015.
Savaga?
3/1/2015.
3/1/2015. And immediately after the defendants came to know about the said transaction, they preferred a partition suit bearing OS number
123 of 2015.
123 of 2015, comma, which is pending on the file of
Civil Judge and JMFC Bangapet.
Civil Judge and JMFC Bangarpet. Full stop. It is submitted in the said original suit. The plaintiff is also a party to the proceedings. Full stop. Next para. In spite of being a party in OS
123 of 2015.
of 2015, comma, suppressing the same, the petitioner, the plaintiff filed OS number
10 of 2017.
10 of 2017, and the trial court and the first appellate court failed to appreciate the right of the defendants and granted the interim order as prayed for by the plaintiff, as prayed for by the plaintiff. Full stop. On the said grounds, it is prayed that the impugned orders be set aside and the interlocutory application filed by the plaintiff be dismissed. Full stop. Next para. Per contra, the plaintiff justifies the order passed by justifies the impugned orders and submits that he is a bona fide purchaser for valid consideration, and that defendants have no right over the suit schedule property and that they have not produced any document to show prima facie they have a right over the suitable property. Full stop. Next para. The question that arises for consideration in the incident petition is, whether, under the given facts and circumstances of the case, the trial court was correct in passing. The trial court and the first appellate court were correct. The trial court and the first appellate court were correct in passing the impugned orders or not. Full stop. Next part. Admittedly, the plaintiff has purchased the suitable property by paying valuable consideration. Full stop. At the time of purchase, the revenue documents reflected the name of his vendors as the owner of suitable property. Full stop. The vendors have put him in possession of the suitable property. Full stop. The revenue documents was standing, revenue documents regarding the suitable property were also transferred in favor of, in the name of the plaintiff. Full stop. The said documents establish that the petitioner, the plaintiff was is in possession of the suitable property. Full stop. Under the said circumstances, the trial court and the first appellate court have passed/upheld the order of injunction restraining the defendants from interfering in the peaceful possession of the suitable property, peaceful possession and enjoyment of the suitable property by the plaintiff. Full stop. I do not see any error in the order passed by the trial court. Full stop. Next part. Graves is entry. Graves are there. Samadhi idya.
Maharaj, photographs have been produced, Maharaj. Photographs at annexure F is produced, Maharaj. Maharaj, suppression of material facts, Maharaj, itself is. Maharaj, with your Lord's kind permission, Maharaj, one judge, once.
It's a well settled law. It depends on facts and circumstances.
No, Maharaj, similar facts, Maharaj.
So here,
Maharaj, in this also, there was a prior partition suit, Maharaj. Suppressing that, he has filed an injunction suit. The coordinate bench, Maharaj, has refused to grant a discretionary relief under Order 39.
I'm saying also protecting your interest, man.
Maharaj, the ingress to the properties also will be, by making such an observation, Maharaj, my performance of puja to the burial grounds, Maharaj, is this man.
Just don't Ingusran hogbit puja manala.
Once, my Lordship may kindly look into this judgment, Maharaj. Let's kindly come to para 5, my lords. The petitioner has filed suit for partition and separate possession in OS so and so. The present respondent plaintiff is restrained by way of interim injunction from alienating the suit schedule property. my lord.
Interim orders ಇದೆಯಾ partition suit ಅಲ್ಲಿ ಅಂತ ಕೇಳಿದ್ರೆ
ನಮ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ, admittedly it's not.
that makes the difference.
But it's pending, next line, madam, pending consideration of partition suit. The respondent plaintiff files bare suit for injunction.
Injunction against all the alienating, that's the reason.
But it's,
That makes a difference, counsel. All the things need not be extracted over here. See, we are balancing the equities, don't worry about it. ಏನ್ ಬಂತ ಹೇಳಿ? ಅದಾದ್ಮೇಲೆ ಎಕ್ಸ್ಪೈರ್ ಏನ್ ಹೇಳ್ದೆ? In the order of the trial. In the order passed by the trial. Full stop, next part. However, taking into consideration the fact that defendants have filed OS number
123 of 15
OS 123 of 15
for
for
partition.
partition and separate possession of the suit schedule property, in which defendant is also a party to the proceedings. Party to the proceedings.
And yes,
In fact, where you did not succeed in OS, now you are succeeding in this petition.
but he in the it's one submission.
Your OS, man, in your OS, there is no order of non-alienation. Now I am granting it for you. Be happy with that. ಏನ್ ಬಂತ? In which so sentence ಹೆಂಗ್ ಶುರು ಆಯ್ತು? ಆಯ್ತು ಬರ್ಕೊಳ್ಳಿ. Equities would be balanced. Equities, equities would be balanced if the interim order, if the impugned orders are modified to the effect restraining the plaintiff from creating any third party rights or change the nature of the property. Till disposal of OS number, NIM OS 10/70. Full stop. Can I record your consent? Can I record your consent? Okay. Full stop. Hence the following order. The orders passed in the impugned, the orders, but the impugned orders restraining the defendants / petitioners here from interfering with the peaceful possession of the suit property by the plaintiff / respondent herein is upheld. Full stop. Next, however, respondent / plaintiff is respondent herein / plaintiff. Plaintiff is restrained from alienating or otherwise encumbering the suit schedule property in any manner whatsoever. Or change the nature of the same till disposal of OS number, so and so. Next. Respondent slash defendant is also restrained from disturbing the graves, if any, on the suit schedule property. If any, on the suit schedule property. Pending disposal of, till disposal of OS number so and so. Next, it is needless to state respondent slash defendant, plaintiff is permitted to cultivate the suit schedule property.
That's why we explore expeditious disposal of injunction.
That goes without saying.
Madhukaran Deshpande.
It's I appear for the petitioner, seek for a short accommodation, scenery is not keeping well.
The request of petitioner call after 2 weeks.
Any date next week.
You want date or 2 weeks? 2 weeks is okay.
Any day next week.
You ಹುಷಾರಾಗಿ memo movement ತಗೊಂತೀವಿ. When you want, you move a memo, we will get it posted. Yes.
18, Mithun SK.
Ready both sides?
Ready, my lord. My lord, in this petition, I have challenged the order passed by allowing the amendment application by order dated 25/7/2018, my lord. The impugned order is found at ink page number 10, my lord. My lord, what they are trying to do with by way of this amendment application is, initially they had filed a suit for injunction, my lord. Later on, they wanted to convert the injunction suit to a declaration suit. So that is the reason they filed this amendment application.
All right.
No, my lord. My only contention, my lord, here is the limitation is it has been time barred. My lord. They have challenged the relinquishment date.
I'll give you liberty to file fresh written
No, my lord,
statement.
it is clearly time. I am producing few citations wherein when it is clearly time barred, where it cannot be allowed, my lord.
How, show me how it is time barred.
My lord, first they have challenged, kindly come to the amendment application.
First, show me the plaint.
Plaint, my lord.
Yes.
My lord, plaint is found at ink page number, annexure B, ink page number 17. My lord, kindly come to para number 4, my lord, of the plaint. It is found at ink page number 20. In the meanwhile, on account of development, shall I read that, my lord?
1 second, wait.
Annexure B.
1 second, Appa. Amendment application.
Well,
show me the amendment application.
Amendment application is at
ink page number 44, annexure E. They sought a prayer.
Who executed the relinquishment deed?
My lord, we have
Signing of the developer. Not, I had executed a joint development agreement in favor of one person X. Lord, the X passed away. Somebody claiming under X, my lord, executed a relinquishment deed. Even though the joint development agreement and GK did not provide for that. The arbitration proceedings, you had said that the relinquishment deed should be declared as null and void. What the learned arbitration said from my lord is BBMP is involved. And since they are not parties to that, please educate it in a civil suit. That is why the amendment came to be.
Correct, but that has to be filed within limitation, no?
That is what.
The question was pending before the arbitration tribunal. Arbitration
No,
tribunal
that
said-
does not say limitation, right?
But if the arbitration tribunal says no, I will not adjudicate it before the civil.
No, show me the case law or the relevant provision of law by which you get a right. Because see, section 14 is not applicable to original suits.
Section 14 is not applicable to original suit, but
Ah.
if I have spent time a lot in the arbitration proceeding,
No, show me the case law.
anyone cannot fixate on the ground of merits of the amendment.
No. See, it's like this. When you are not entitled to file the suit itself, you can challenge the amendment. You can object to the amendment. See, see, the law says within 3 years from the date of knowledge.
Yes,
Okay,
madam. Yes, madam.
admittedly, 3 years from the date of knowledge has expired. Which is the article, Limitation Act?
58, my lord.
But this was raised before the arbitrator law. Arbitrator law passed an award dated 28/1/2016.
See, Abhinav, the onus is on you to show that under the circumstances, you get a right. That's okay. I don't want. See, facts are not in a dispute over here. He is also not disputing that
I'm not disputing that.
arbitrator has passed that award or whatever. His contention is this application was made on 2/11/2017. The document was executed on 12/1/2010.
12/1.
Okay, even otherwise, taking into consideration your pleadings before the arbitrator and all, you definitely had the knowledge about that relinquishment deed much prior to 3 years before.
Those are the dates I have to place before my lord.
Ah.
Because I have not executed it. When I came to.
You need not execute it. What have you said with regard to your knowledge? You have to produce it. And it is, the onus is on you completely. When do you want it? Take a date. 10 days with time.
The entire plaint government states about relinquishment, but they don't challenge it. In the entire plaint government, they speak
The
about
onus is
relinquishment.
heavily on you. But the request of respondents, call on, date put it,
23.
23rd.
Any date, any date.
19, E. Balakrishnan Shastri.
Seek an adjournment, my lord.
The request of petitioner, call after 2 weeks.
Great. 20, P. N. Harish.
petitioner.
One second. Sharath, objection ita. They came and asked for time, I granted you. Borodrogade adjana with matter. Yeah, you are ready. Last time you took time, right? Yeah.
Lord, the impugned order is refusing to come on record the petitioner
Hmm.
as a legal representative of the first respondent.
Hmm.
That is questioned here. Because what has happened is a suit for declaration and partition was filed by the petitioner along with his mother-in-law, wife and one sister-in-law against father-in-law and two sister-in-laws.
Hmm.
And the claim of the petitioner was that he is an illegitimate son and should be treated as a biological son, and he has got all the rights as that of a son. That is a declaration he has sought for, along with partition and maintenance for his mother-in-law.
Hmm.
I mean, yes. So that suit, my lord, came to be decreed partly, awarding partition to the joint family members. And so far as the declaration is concerned, that has been refused. Against which appeal is filed by the petitioner.
Any scope for mediation?
But
Mediation in scope idea.
yes, what is the problem is the respondents have not appeared before the sample court. Then the coordinate bench on when I was arguing it, they thought fit that since it needs to be allowed, let there be an amicus curiae ಅಂತ appointment ಮಾಡಿದ್ದಾರೆ. ಅವರು participate ಮಾಡ್ತಾ ಇಲ್ಲ, ಬರ್ತಾ ಇಲ್ಲ.
Do you have any instructions from the respondents or not?
ಇಲ್ಲ, ಅವ್ರಿಗೆ ಏನು ಇದ್ದಂಗೆ ಇಲ್ಲ.
Just assist the court on point of law. Okay, then go on.
Please.
Which is the order impugned?
That impugned order is at page number, annexure F, my lord. Page number 77. The learned judge, my lord, has, in his order, has narrated all those facts which are actually in line with the arguments that has been submitted by the petitioner, but only one line I am aggrieved.
Writ petition ಯಾಕೆ ಬಂತಿದ್ದು? RS ಆಗ್ಬೇಕಿತ್ತಲ್ವಾ?
ಇಲ್ಲ, ಆರ್ಯ ಪೆಂಡಿಂಗ್ ಇದೆ ಸುಮ್ಮನೆ. ಆರ್ಯಲ್ಲಿ
What is an IA 3?
ಆರ್ಡರ್ಸ್ ಆನ್ IA.
ಇಲ್ಲ ಟೋಮ.
ಇಲ್ಲ ಟೋಮ್ಸನ್ ಅಳಿಯ ಮನೆ ಅಳಿಯ ಅಲ್ಲಿ ತೀರ್ಥಹಳ್ಳಿ ಕಡೆ ಒಂದು ಪದ್ಧತಿ ಇದೆ. ನೋ ಮೇಲ್ ಚಿಲ್ಡ್ರನ್ ಇಂದಾಗ ಅಳಿಯನ್ನ ಮನೆ ಅಳಿಯ ಮಾಡ್ಕೊಂಡು ಅವನ ಮಗನಂಗ ಟ್ರೀಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಶೇರನ್ನು ಕೊಡೋ ಕಾರ್ಯಕ್ರಮ ಇದೆ. ದರ್ ಇಸ್ ಎ ಕಸ್ಟಮ್. So based on that custom, my lord, the suit has been filed. It is an undisputed fact there is an illegitimate son.
You are the illegitimate son-in-law?
Yes.
Huh?
Illegitimate son-in-law.
Okay, now
The first respondent is my father-in-law who died during the pendency of the appeal. That is on 16. So thereafterwards an application is.
now listen,
Please.
Basavaraju is your son.
Yes,
Who is Dugappa Goda is your father-in-law?
father-in-law.
Huh?
House.
Who is Vasanta?
Vasanta, my lord, is the sister-in-law, my sister-in-law. Vasanta and Hemavati are the other two defendants who are my
Her
sister.
sister-in-law.
Kindly see annexure A, my lord, client.
Bhudevi is your wife, huh?
Bhudevi is my mother-in-law. Mother-in-law died.
No, it shows wife of Basuraju.
No. Bhudevi is mother-in-law, my lord. Bharat, yes, Bhudevi
Bhudevi is
is
your
the
wife,
daughter, yes, wife.
Parvatama also died, huh?
Paratama. OSL ಇದ್ದಾಗ
Okay, she is also dead.
dead.
Vishalakshi is another daughter.
Yes, was,
Huh?
yes. Vishalakshi, my lord, Vishalakshi, Vasanta, Hemavati and Bhudevi are the four daughters.
Hmm.
I am married to Bhudevi. Nagaratnam, Parvatama and Dugappa Goda are my in-laws. The suit is filed by petitioner herein that.
ಮಾವನ್ ಕಾಲ್ಗಿಲ್ ಒತ್ಕೊಂಡಿದ್ರೆ ಅವರೇ ವಿಲ್ ಮಾಡಿರಪ್ಪ. ನೀವು ಚೀ ಥೂ ಅಂತ ಹೋಗಿದ್ರ
That suit is fine.
ಹಾ ಅಲ್ಲ ಅದೇ ಆಗಿರೋದು. ಹೆಂಗಿದ್ರು ಮುದ್ಗ ಸತ್ತೋಗ್ತಾರೆ ಹಂಗೆ ಹಿಂಗೆ ಅನ್ಕೊಂಡು ಆಸ್ತಿ ಎಲ್ಲ ನನಗೆ ಬರುತ್ತೆ ಅಂತ. You let your life.
He is residing along with them only. He has quit his family, is residing along with them only. ಅನ್ಯಾಯವಾಗಿ ಇದ್ದಾರೆ.
That's what. You are not care for him during his death also. No.
It's all merit of the case.
ಅಳಿಯ ಸಂತಾನ. ಇದು ಅಳಿಯ ಸಂತಾನನೋ ಏನಿದು? What is?
But the question is now, Millard, whether I should be brought on record as a legal representative, keeping open my entitlement for share. That is the only issue.
Yeah.
That's the only issue. Ultimately, in the RA, the Honorable Court will decide whether I should be treated as a biological son or not is a different aspect. Before that, the doors cannot be shut. That is my respectful submission.
Show me the provision of law under which you are entitled
Millard,
to.
I am only concerned about the only one line of the order, Millard. The rest of the things are in my favor only. Millard, kindly come to page number 83, last portion. Fifth line, Millard. It starts with as discussed Supra, your lordship got it. As discussed Supra, all the legals of the first respondent are already on record, and the question whether the appellant is a legal heir has to be decided in the appeal. In my view, the appellant cannot be brought in record as the legal representative of the first respondent. This is affecting. Now tomorrow, Millard, the Honorable Appellate Court holds that I can be treated as a biological son, I'm entitled to a share. Then I will not get any share because the share left behind by the father-in-law. That door will be
Show
shut.
me under what provision of law
Please.
you are entitled to a share.
Millard, under Order 22, Rule 3, Millard, even a person claiming to be a legal representative could be brought on record. The decisions have been cited by me before the learned trial judge also. That has been considered. But while passing the order, this mistake is done. Kindly see, Millard, in page number 81.
Now show me how you are having a right over the property under what provision of law.
Millard.
Show me the provision of law.
Please, Millard, my respect submission is that is to be decided in the regular appeal.
No, it's a question of law that can be decided. Evidence is required, then it's a problem. For a moment, let us assume
Please.
that you're pleading that your illatum illegal, whatever, son-in-law you are. Okay?
Yes.
We'll presume that to be correct.
Yes. Then, Millard, I should be treated as a legal heir.
No, listen.
Please.
Let us for a minute presume that you are illatum son-in-law. Your Manaliya. We presume that.
Please.
Okay. Presuming that you are Manaliya,
Till you got.
show me a provision of law by which you are entitled to have a right over the property of your father-in-law, then I'll grant you the relief.
Please, my submission is kindly see the plaint government for that. They're not question of.
I've seen the plaint governments.
Please.
You have made a prayer to that effect also.
Yes.
Okay.
So that is
No,
pending
no.
consideration. That is my.
That is
submission.
different. Pending
Please.
consideration is different. This court can always examine. See, it has to cut short the frivolous litigation. Okay. It has to cut short the frivolous litigation. On facts, whatever you have stated, let us presume for a minute
Yes,
They
I
are
understood,
true.
my lord. I understood.
They are
It's-
true. We are
it's
not
right.
disputing it.
Please,
Even under those circumstances, show me the provision of law, how you are entitled to have a right. Because in my opinion, that is not so. That is not so. You are not entitled to.
please.
Show me the provision of law, either in the statute book or
Customary.
the case law. Case law, customary is different.
Customary.
That
I'm
custom has to be recognized by the statute. See, you
Customary
are a
act,
Hindu
only
for
on
the
the
purpose
custom-
of Hindu Succession Act, right?
Yes,
Yes.
that is true. my lord.
Mitakshara has been substantially amended.
Yes, yes. I
Okay.
don't dispute all
So
those.
though Mitakshara is the basis for Hindu law, for all practical purposes, it has been substantially amended. It is no longer valid. Okay, so show me the provision of law under which a Manayaliya is entitled to a share in the property.
ಅಳಿಯ ಸಂತಾನದಲ್ಲಿ ಬರುತ್ತೆ ಸೌತ್ ಕೆನಡಾದಲ್ಲಿ
Sir,
it is in practice.
ಇಲ್ಲಿ ರಾಜಕೀಯ ಭಾಷಣ ಬೇಡ.
ಅಲ್ಲ I will
ನೀವು
show, I will
ಕಾನೂನು ಪುಸ್ತಕ ತೋರಿಸಿ.
ತರ್ತೀನಿ I will look into that.
When do you want it? Tell me. Date ಕೊಡಿ.
Next week ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡಿ.
17th,
ಅಲ್ಲ 17 18 ತನಕ ಟ್ರಾವೆಲಿಂಗ್ ಅಲ್ಲಿ
ಆಯ್ತು, 19th.
19
At the request of petitioner, call on 19th.
free model.
Interim order, if any, is extended till next date of hearing.
SN, but.
Then what is no more.
No more.
It is submitted to the bar that the learned counsel for the petitioner is no more. Full stop. Issue court notice to the petitioner.
22. Markand City.
None appears to the petitioner. This was for non-prosecution matter. Even on the last occasion, none appeared for the petitioner. The
23.
petition is of the year 2018. Gottala. Yes.
23. Dhananjaya KV.
The Lordship, Mr. Dhananjay for petitioner is retiring from this case. I have also filed the same in the registry.
The advocate for the petitioner submits that there are no instructions to go on with the matter. And
Lead counsel will be Mr. Sudarshan Suresh.
there is an advocate.
Your Lordship,
There will be an advocate.
please, yes.
Okay. Then, but at the request of petitioner, call next week. He has to file his wakalat.
He's already in the wakalat.
Okay. Registry
Yes.
is directed to show the name of free. So and
Sudarshan
the
Suresh.
advocate appearing for the petitioner. Barcode. Chittinal.
24. Anil
Petition, press time next week.
Okay.
Another colleague is argue the matter. That's
At the request of petitioner, call next week.
25. DN Anant Narayana.
For the respondents, my lord.
Last date of fair amendment is second time.
We are ready, my lord, on consent, my lord, the order can be modified.
When consent of.
The trial court may direct to dispose of the suit. There is a status order from last 6 years that may be continued till disposal of the suit.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು ಈ ಕೋರ್ಟಲ್ಲಿ
ಹೌದು ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ಸ್ಟೇಟಸ್ ಕೋರ್ಟ್ ಡೈವರ್ಜೆಂಟ್ ಆರ್ಡರ್ ಇದು ಸ್ಟೇಟಸ್ ಕೊಟ್ಟಿದ್ದು on 11/3/99.
Yes, this court by order dated 11/3/2019 directed the parties to maintain status quo in respect of the suit schedule property. Full stop. Next para. After arguing the matter for some time, both the advocate for the petitioner as well as the respondent submit that they will maintain status quo in respect of the suit schedule property till disposal of OS number 79 of 2016. And the trial court may be directed to dispose of the matter as expeditiously as possible. Full stop. Hence the following order. Parties are directed to maintain status quo in respect of the suit schedule property till disposal of OS number 79 of 2016 pending on the file of so and so. Correct ತಾನೆ?
ಹೌದು ಸ್ವಾಮಿ.
Pending on the file of so and so.
That's made quick for a time frame, my lord.
As the original suit is of the as the original suit is of the year 2016, the trial court is directed to dispose of OS 79 of 2016 as expeditiously as possible. Writ petition disposed of accordingly. Time frame ಕೊಡಬಾರದು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ. Yes.
ಅವರೇ ಸದಸ್ಯರು. 26, Manmohan PN.
Lords, I'm for the petitioner.
And for R2.
Your Honor, on the 25/1/2024, as per this honorable court order, the RFA 1147 of 2017 would be bearing on this writ petition, and we have moved the RFA.
You want time?
Yes, sir.
They've been intimated. No objection.
The request of petitioner call after 2 weeks.
Maybe after 30th September, the RFA.
Call after 4 weeks.
27,
Interim order may be extended.
Interim order if any is extended to next date of hearing.
G1 J Nilargi. GR Anantram.
Respondent number 1 by party. And the net front had to file the amended petition. I don't know whether he has filed.
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
Amended petition ಹಾಕಿದ್ದೀನಿ. ಅದು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಮಾತ್ರ amendment. ಎಲ್ಲಾರ್ಸ್ ಆಫ್ respond number 2.
Then you can go on with the matter.
Please.
I thought hello.
No. Audio ಏನು ಮಾಡಿ. File on 21st August, sir.
Impleading ಏನಿದು? IA 1 of 2018 who has filed?
My lords.
Impleading applicants are.
They are impleading applicants are the my lord, the residents of the my lord, the apartment complex. I think the my lord, they have not served the copy.
They have not served me also. Some of the apartment owners,
Yes.
they have filed this application.
Yes, who appear for impleading applicants? Serial number 27.
Earlier, I remember Mr. D.R. Ravishankar, I think, was appearing.
I think it's all right. You go on with the matter. What is this? Let's see.
Please.
All of this is a writ petition filed by the receiver, court appointed receiver. The issue is, my lord, the plaintiff is the my lord, the developer, who is the first respondent herein. Files a suit, my lord, seeking direction to conduct an election to the my lord, the complex. Until then, to appoint a receiver to manage the my lord, the apartment. My lord, the respondents, defendants were, my lord, the landowner, as well as, my lord, certain associations which were claiming that, my lord, they are the, my lord, the representative, authorized representative of the, my lord, residents of the apartments. So there was, my lord, which the, my lord, the builder disputed their thing. See, he approaches the court. Lordships may kindly turn to, my lord, the receivers, sorry. 317, my lords, page number, ink page number. They are the prayers in the suit.
Page number?
317, my lords. Ink page number 317. My lord, sir. Lord, the plaintiff prays that the honorable court may be pleased to pass.
317 ಬೇರೆ ಏನೋ ಇದೆಯಲ್ಲ?
My lords,
Something else in our paper book.
like, just Lakshmi kindly.
ಕೊಡಿ.
Some. Even, just.
ಅಲ್ಲ, ಯಾವ್ದು ನೋಡಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಕೊಡಿ.
Writ
ಕೊಡಿ
petition.
ಅವ್ರಿಗೆ ಕೊಡ್ತಾರೆ. ಇದನ್ನ ಕೊಡಿಯಪ್ಪ.
Not a prayer I'll give. There may be some mistake.
Who appears for?
My lord, 322, your lordship,
response-
sorry.
Respondent number 2, he passed away during the pendency of this petition. His
LRs
sons
are on
and
record.
daughter have been served. They have not represented.
322.
Respondent number 3.
Respondent,
Okay. You take care of the interest of the owners also.
No, no.
Under Societies Registration Act or Apartment Ownership Act? Are you sure? You are registered under Apartment Ownership Act.
he claims to be an association of certain apartment owners, while our suit is for bringing all the apartment owners as is required by section 3D of the act. That's what my endeavor is. From 2012, I'm fighting for that.
Now this writ is filed against what?
My lords,
What order this writ is
my
filed?
lord, this is an order passed by the, my lord, the court below, allowing the application filed by the plaintiff, where, my lord, he has sought a direction from the receiver and sought a recovery of the amount past dues, which was, my lord, allegedly due to him, my lord, according to them, builder. That is before the appointment of a receiver. My lord, he claims that, my lord, there are certain dues which is entitled to from the residents. Since the receiver has been appointed, he has stepped into the shoes of the residents now, association. And my lord, he wanted to recover that dues from the receiver. For that purpose, my lord, he has sought, my lord, production of, my lord, books of accounts, etc., audited books of accounts, etc., my lord, which we have produced, but we oppose the, my lord, the prayer for a recovery from the receiver. My lord, this honorable court, my lord, granted an interim order held that, my lord, there cannot be any recovery from the receiver, my lord, are still imposed. That is the application. Your lordship may kindly, my lord, the application is at Annexure D, 327 to 339. Application, your lordship may, for a moment.
1 second.
The lordship may Annexure A is the, my lord, order passed by this honorable court wherein, my lord, the receiver was appointed.
So plaintiff is the developer, eh?
Yes,
Huh?
yes, my lord.
Plaintiff is the.
Plaintiff is the developer.
Okay. Who is the owner of the property?
The respondent number 2 here in, my lord, who is no more, his LRs have been brought on record. my lord.
Okay.
There is no list between the, my lord, as such, because property is completely developed and, my lord, sold. Apartments were sold to the, my lord, the residents.
Now, what is the right of plaintiff? What is the prayer made in the suit?
My lord, your lordship, can you see the prayer, my lord, 322 in that.
1/6.
322, your lordship, may can you see page number.
1 second. 6 is.
Page number, prayer. ಸ್ವಲ್ಪ page number ಆಗಿದೆ. ನಂತರಲ್ಲಿ 37 ಕರೆಕ್ಟ್ ಇದೆ. ಕೋರ್ಟಲ್ಲಿ ಇಲ್ಲ. ಓ ಅದಾ.
Then after this original suit, where is the order appointing you as the receiver?
Yes, my lord. Annexure A, lordship, may, it is in MFA, my lords. Lords, may.
No, this is the original suit pleading ಆಯ್ತು. Annexure A.
ಆ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ
Order appointing you as the receiver ಇಲ್ಲಿದೆ.
ಈ lordship may ಕಳಿಸಿ, my lord. That is the, that reached this honorable court. By consent, my lord, before this honorable court, a receiver.
Show me that order.
Yes, my lord, Annexure A, Your lordships may kindly take, my lord,
Annexure A is the.
in that miscellaneous first appeal, my
In
lord.
page 13.
3209 of 13.
In page 13 of that office paper.
From 14 it starts. Fifteen, your lordships may, the aforesaid case was referred to mediation for resolving the dispute between the parties. In the course of mediation, the appellant and the first respondent have, without prejudice to any contentions of either party in any other proceedings, partly resolved the dispute and have agreed to the following terms and conditions. Lord number 2, both the parties agree that this settlement is restricted to the issue relating to the appointment of an official receiver to take housing apartment complex. The appellant and respondent number 1 agree that the follow and whose names have been suggested by the appellant shall constitute a committee to be known as the South City Maintenance Committee. My lord, the names are there. My lord, 5 names are there on ink page number 16, sorry. The aforesaid South City Maintenance Committee shall be designated and appointed as the official receiver under Order 40 Rule 1 of the Code of Civil Procedure. In view of the aforesaid agreement entered into between the parties pray that the above case be disposed of in terms of the aforesaid agreement. Lordships may.
You'll continue it after tomorrow?
Please.
Heard in part? Not at the date code.
11.
Yes. Other matters stands adjourned. Date code, date code.
Day after tomorrow, my lord.
Yes.
Please.
11.
Please.
Heard in part of.
Yes.
Just finished up. Yes, 28, 29, 30.
28, 29, 30.
If you want a date, you take a date, it stands urgent.
Much obliged.
You tell it to the court office.
Rematter may be extended till number 29.
ಎಲ್ಲಿದೆ ಇಂಟ್ರಿ ಮೋಟರ್ ಇದೆ ನೋಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಇಟ್